that the decree is not binding on you.
No, I'm not saying that, Your Lordship, but if Your Lordship kindly takes it.
Why will I take it up? You tell me a good reason.
Lordship. Much obliged, Your Lordship.
Your Lordship.
Much obliged.
Your Lordship, may I permit to mention a matter?
Yes.
It is for inclusion in the list.
No, don't mention for inclusion. Yes. Call the list.
Your Lordship, kindly grant me leave to
Yes,
mention a
yes,
matter.
yes. Yes, you have been trying for years.
Mention
Trying for a
at
couple
least
of
on
days. Yes, yes. Tell
attention
me.
of my lord is drawn.
Yes, yes. Tell me which matter.
Yesterday, the one I was mentioning.
Yes. What is the matter? You tell me.
My lord, 302-1148.
Yes.
1458.
Yes.
Design matter. My lord.
Oh, this is before his
That is
lordship.
why I'm mentioning. I'm just seeking my lord's attention.
Yes.
My lord, I have a fresh copy, but I've just marked for
Yes,
us.
yes, yes.
My lord, section 2O.
Yes. Sir, this, I understand what is your problem. Such similar problem arose in respect of another matter. A court under constitutional provisions exercising jurisdiction under Article 227 is not denuded of its jurisdiction to hear a matter.
No, it is
But
not.
please
Here it
understand.
is said,
So therefore, I am not.
transfer is also dated section 11.
No. This is not binding on to that extent on the constitutional courts. Please understand.
I'm not.
If you are interested,
Matter.
no. If you are interested, you file a separate.
Please upgrade the matter, my lord. I'll tell you the predicament.
Because you see, I will not entertain.
Urgency, my lord.
Please
And I'll
understand.
tell you why the urgency lies.
Please understand. Please understand. Since this matter pertains to intellectual property rights, and a court is exercising jurisdiction and having a determination in respect thereof, by reasons of the alternative remedy, this court will not take up the matter.
But this is not alternative remedy, my lord. It also says, especially section 2, subsection O, clause 6. 226, 227, both will be transferred. That is mentioned. It's not section 2, subsection O, subclause 6.
Yes.
And then, my lord, be pleased to come to.
No. It says proceedings shall mean. Now, oh, very well. You show me.
Yes. And then, my lord, comes to section 11 of this Gazette notification.
Yes.
This lays down the procedure, how it will be.
Yes.
A.
When was this notified?
This was date of notification was 20. It's on 22nd of July 2024.
Yes.
However, the practice came into action only when after the puja vacation the court was constituted. That is 4th of November. That is the effective date, my lord.
No, have you said this?
It is available.
You take back the petition and file, sir. I am not inclined there. I have to consider this matter in that case.
But
এটাকে দিয়ে দাও, আইটেমটাকে দিয়ে দাও লিস্টে next week.
But even if my lord hears it, it's
I will no, I will not, because there is an alternative remedy available to you.
the date. I'll just.
On 29th. Because matters are fixed otherwise.
My lord, just one consideration. What happens, my lord, is this concerns a medical equipment which produces.
Okay, come on 21st. Let us try. Let's find out. If I can, I'll place it on 21st.
Much obliged, my lord. Much obliged.
Yes, call the list.
Lordship, I had mentioned this matter
Yes.
in December, and then I had expeditious disposal matter of grave urgency. Whenever the matter had come up for hearing in January in 2024, 12 months, the matter has not been heard due to some reasons like adjournment due to resolution of the local bar. The matter was never heard in the entire year. Matter is fixed on 17th before the Court of First Civil Judge Junior Division, Alipur. If you could kindly hear this very small matter, expeditious disposal.
Yes.
My lord, the next date in the suit, my lord, before the court below, is on Friday. My defense has been struck off. I'm a tenant.
Yes.
The suit was filed on account of arrears of rent. I filed an application.
Which item?
My lord, 115 of today's list, my lord, daily supplementary list. My lord, I tell your lordship what has happened. No chance has been given to me to
It'll appear. It'll appear. I can't say when, it'll appear. It has been upgraded. Yes, call the list.
Item number 1,
By my lord, yesterday, I went to vote. I said in the daily. Sort of bus also. My lord is serious. That is.
I will consider this matter. I'll consider this matter. I'll consider your matter when it makes submissions. Yes.
the matter related to the
Why is it appearing under the heading extension of interim order?
first officer on 3rd July 2024.
Yes.
Honorable Justice Vishwajit Basu was staying the lower court proceedings of title suit, and thereafter on 9th December 2024, the Honorable Justice Vibhas Patnaik was extended the interim order for 6 weeks. That's why they are going to that's why I mentioned this matter. The matter
Interim order dated 3rd July reinstated, and it is for 6 weeks from 9th of December. It is valid. You have served on the other side.
the previous officer on direction compliance with the court's order dated 7th
What is the matter? What is the matter?
the order wants to change, but the inclusion of the additional party in the partition too. I am the second class legal here. I am the second class legal here, but intentionally not included me as party in this partition. But in the previous officer, another 2005, there our name also included. But this
Who are you?
I am for the PDG son of this deceased owner. PDG sons of the deceased owner. Deceased owner has no first class legal.
You cannot be a PDD son of a deceased owner. Please, sir. Who are you? You are the legal heir of the predeceased son of a legal of the deceased owner. Fair enough. So why? Predeceased son. Very well. And you have not been added as a party.
Initially added party, then another partition. The 86th of 2022. Like to kindly see this.
Yes. Place the order. Which is the order?
Like to kindly see this. 21 days. Place 39. Here their name, the Sapal Kumar Pal is
Therefore reveals.
that name also petitioner also included in this party, in this partition. And thereafter, it was dismissed for default, page 27.
You are not the, you are the legal heirs of the brothers of the original.
Others, others, the owner, actual owner.
The order records something else. The order records petitioners are admittedly the legal heirs of some of the brothers of the original owner. You are the brother of the original owner. Who was the original owner? No. Be that as it may, mother of Narayan Chandrapal. Acha, predeceased him. So, Narayan Chandrapal is the original owner. Where is your application? Show me your application. Where is your application? Properties of Narayan Chandrapal. Yes.
He died in faith.
Kamala Pal, who is the Kamala Pal?
The
Monindra Pal, Kamala Pal, and namely Keshtava. Who are they?
they are the brothers and sisters.
Where have you written that in your application? Yes, page 29. The court will assume everything. I see their names are there, but how are they related to each other? What you are submitting, the court will assume everything. Then from where do I get it? Where is the plaint? Where is the plaint? Where is the plaint? I will not extend your interim order unless you get a copy of the plaint. Sir, I will not extend your interim order. You go on applying, sir. The petitioner is unable. দেখুন, record করুন. The petitioner is unable. When you can bring it? Monday. Bring it on Monday. And unnecessarily, these matters are kept pending. If you are right, if you have a class 2 here, he does not have a class 1 here. If you can establish that you have an interest in the property, you did not explain in detail in the petition by making out a chart how the parties are related to each other. Therefore, it is necessary for this court to go into the plaint. You will not show me the plaint. No question of application. You get a copy of the plaint, bring it. Yes, bring it. Yes, call the next matter.
But
Not this week. You have no interim order is there. I'm not extending it. Come back on Monday. 21. Yes, Tuesday. Let's get out.
That's it.
Yes.
Item number 2 in this matter.
একটা line দিয়ে দাও. Having heard the petitioner, having heard the learned advocate for the petitioners, let the interim order stand extended till Monday next. When the petitioner till 21st, when the petitioner is directed to produce the copy of the plaint filed in TS number দেখে নিও. Partition pending before the court of. Yes. Next matter. You are for the petitioner. You are asking for extension of the interim order. You did not deposit the amount. Yes. Barashat Eye Hospital was not considered by the learned court. These matters I am hearing, they slipped out. I was hearing these matters. I would have disposed of all of them. Anyway. Yes, madam.
Lordship, in this matter, my learned advocate anonymously is appearing in this matter, and he has
Yes.
come.
Yes. When was the interim order passed? Yes, it expired. Not before this court. You did not mention. How could you mention? I did not have determination, sir. So say so. Jalpaiguri mentioned this matter. How can I extend the interim order? Within time. I cannot extend the interim order. It has to be reimposition. File a supplementary affidavit. Seek for reimposition. Leave granted to file a supplementary affidavit. To incorporate. No, দরকার নেই. Leave granted to file supplementary. File it. Monday, yes. Let them correct. I have stopped allowing these matters. unless there is an appropriate prayer. Yes, call the next matter.
Item number 3,
Yes. When did the interim order expire? Yes. 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 So by the time the interim order expired. Yes, yes. Mm-hmm. I will not do that. First of all, you tell me interim order today. Before extending the interim order, I will refer the matter to mediation, sir. Sir, brilliant, sir. Brilliant submission, sir. Tell me, sir, today the interim order is expired. Please understand, the interim order is expired. Now today, tell me, what do you want? You tell me, what do you want? Why do you want mediation? You want the interim order, you want to raise an objection on the interim order. And you want the matter to be sent to mediation and in the meantime, to suit to proceed. Suit to proceed? Very well. It is a matrimonial suit. You are for the husband. Are you paying maintenance? I will not refer it to mediation. Very simple, sir. Sir, pay maintenance, I'll refer it to mediation. There is an order for maintenance? Yes, sir. There is an order for maintenance? There is no order for maintenance. Then why are you saying he's not paying maintenance? Did you apply for make any application for maintenance? Yes, I'll transfer it. I'll transfer it. I'll leave it for the learned court. Sorry, sir. You want to show any judgments on this? So it is not difficult for you. So it is not difficult for you. Because therefore, so very well. So the law requires that the wife's convenience is to be considered. What do you do? You are a professor. How much do you earn? Only 45,000. You are ready and willing to file an affidavit of assets saying that you only earn 45,000. No, you tell me. I'm asking you, sir. I'm asking you. I'm not saying that. So if you pay the maintenance, I will consider your prayer. Otherwise, no, sir. You have let your wife learning. You're a professor. Monday. First of all, get the Monday. Let him make payment of the maintenance. I will consider. I have not rejected your prayer. You are already out of time. Your application is beyond the time. Please understand. Application is beyond the time. You are asking for reinstatement. Please understand. I am asking him whether or not he is ready and willing to make payment of maintenance. He is saying that he will take instruction and come back. Will the maintenance not help you? I don't know. What do you do? What do you do? Okay. So let us see, come back Monday. Monday, the interim order is not there. I would have understood it is there. In the other matter is there, it is not there. Come back on Monday. Yes, call the list. Same position. Yes, call the list.
Four.
Yes. Yes, who's appearing? Item number 4. Yes. Yes, yes, yes. Oh, I'll take it up as a returnable motion. It's not extension of interim order. I'll extend the interim order, fix it under the heading, returnable motion. Not now. I'll have to hear you. I'll hear you. Having heard the learned advocate appearing for the respective part. I'll decide it on that. Yes.
Item number 5.
Petitioner, you're for the petitioner. Yes. Extension of interim order, whosoever is appearing. Yes. This is a vacating application filed by them. You want to use any opposition to that? The interim order is valid till the instrument application, the application being Everything pending, yes. All, everything. I'll dispose of everything on that day. Yes, call the next matter.
Item number 6.
You did not pay for that. The learned advocate, the learned advocate appeared.
Item number 7.
Where is your submission in the petition? Statement in the petition that your boundary wall is being broken down. They are trying to bring down the boundary wall, which was submitted. Which paragraph it is there, sir? You remember that Mr. Rahiri said that I have no intention to break down the boundary wall, far less to encroach upon your petition. Where is that statement in the petition? Even the present divisional application will also do. Forget the appeal. Yes. Your boundary wall is being interfered with. I understand. Something their relief was sought for not to disturb their constructing of the boundary wall. The court granted an injunction in their favor. So this is your first contention. No, injunction in their favor in respect of the entire suit property. Correct. So therefore, this is beyond the scope. That is your contention. See, that was not submitted yesterday. See, Mr. Dotto, you had said that being agreed, Mr. Dotto would submit that the aforesaid order cannot be sustained in any event. You would submit the opposite party on the strength of the order is attempting to demolish the boundary wall of the petitioner. And that was the submission made, which prompted the court to take up the matter. Yes. Where is Mr. Bose? He's not online also. That does not matter. You are there. Yes. Now how do you clarify this position now? Yes.
My subparent H of my lord kindly see para 5. What was our contention before the fact? There was no existence of any boundary to us. Ground of challenge before the this court is that without there being a finding written as to the
Existence of a boundary wall, how could the learned judge, my lord, pass this order? No finding regarding position, no finding regarding
Not going to
existence of
reheard
boundary.
this today, only clarification on this. So there is nothing.
Statement, that statement, lordship is correct, is not there.
Is it a fact that that boundary wall is being attempted to be broken?
My lord, let me clarify the situation
No,
first.
it's a fact.
Otherwise, there will be another confusion.
No, Plus, tell me this first, and thereafter, is it a
My lord,
fact that
he is trying to, the fact
he's
is,
trying to encroach
no, he is trying to reconstruct
a
a
boundary?
boundary wall, in the process trying to encroach into my property. That is my problem. My property is, my lord, a 6.61 acres of land. Within that property is this 25 kathas
Where
B
is Mr.
schedule property.
Lahiri? Can you get hold of Mr. Lahiri once?
I can, my lord, I don't have his number, but
Get hold of Mr. Lahiri. I'll keep it pending because this.
May I
was the
request this, my
consideration on which this
Very-
order was passed.
my lord, kindly
I'll keep
keeps
it
it tomorrow.
pending.
Tomorrow.
to-
I want Mr. Bose also to be here. That's the reason.
That is different. What will he say? If he's not there, it is not there.
No, I won't be there, my
Apart
lord,
from
after
cutting
the.
a sorry face, nothing will be there. So I want a clarification today. Since you have given that clarification,
No, I want to
Mr.
do
Lahiri
it in
now.
his presence, my
Yes,
lord.
so now Mr. Lahiri has to be there.
I will inform him.
Kindly info, I'll take it up at 2.
My lord, I won't be there.
When you will be leaving?
My lord, I have to go, my lord. I have a matter. I am on legs, my lord, before the commercial court, and I would.
Rajarat?
Yes, my lord.
At what time?
My lord, it's around 1 o'clock. I won't be back by 2 o'clock.
Very well, I'll give it at 12. Ask him to come.
12 o'clock.
Ask Mr. Lahiri to come. I'll take it up. I've disposed of, I've passed an order in the
Very well.
matter.
I'll just try and, my lord, contact
I
him,
want
and,
to
my
keep
lord.
these matters pending.
Lordship remembers I told that this may take some time. I wanted to take your lordship.
No, that is not an issue. But I will hear you on main merits, but because the consideration for granting that injunction
That
is different.
statement is there, then it will be
Yes,
difficult.
I have a very bad habit of checking paragraphs.
No, I
What
understand.
can
And
be done?
in fact, these saves, my lord, higher up, my lord, somebody would say this was not even the case run in the petition. I understand.
Ask him to come. Yes. हाँ, pass over about it.
Item number 9.
Lordship, I beg to appear on behalf of the applicant, my lord. My lord, before starting the matter, my lord,
Urgency.
my lord, one thing I should share before your lordship. Lordship, applicant is the widow woman and doing maid service. It is my pro bono service to her, my lord. It is being a lawyer, my lord. It is not my duty to collect
No, what
money
is
or
the urgency?
enjoy-
Come and say this.
urgency is that, my lord, kindly, my lord, I have challenged the order dated 24th April 2024, my lord, where I made one application under order 39 rule 7, my lord, just to appoint the officer, commissioner, advocate commissioner.
Why?
Shoot at the shoot property.
Why?
To inspect. Reason is that, my lord, picture, my lord. Kindly have a
No,
look.
no,
my lord.
why? Why inspection?
my-
What is your suit for?
Shoot for declaration. I need some repair work.
Oh,
at
for
the-
repair work.
Only for repair, nothing else. My lord, kindly have a look the picture of the property, my lord, kindly. That is annexure P4, my lord. P4.
Very well, serve a copy of the application.
My lord, in the meantime, my lord, kindly stay the proceedings before the
Well,
court
6
below,
months
because
have passed. 7, 8 months have passed. I'm not going to stay.
lordship, there is a
7, 8 months have passed. I'm
I
not
have-
going to stay.
I have several times tried to get it done, my lord.
No, no,
It is
no.
not possible to have the
Challenging
matter
the order dated
because we not
24th of
issue
26th April
proceedings because
The petitioner shall be at liberty to pray for an adjournment before the learned trial court. Yes, next.
My lord, I am for the petitioner.
item number 10.
My lord, after,
Yes.
after mentioning the matter.
Is
and-
this a matter, caveat is there?
My lord,
Caveat is there?
my lord, the matter
Have you
was
filed
heard.
caveat?
The
There,
matter
there,
was
there.
heard,
Continue, continue.
heard, my lord, but the matter was
Have you
heard.
filed caveat?
My lord,
What is the
Justice-
matter?
Justice Basu, my lord, this is pertains to a custody of a child.
Yes, yes, yes.
My lord, what happens, my lord, Justice Basu has been hearing this matter for some time, and in course of the hearing, my lord will kindly look at this order. My lord, everything turned around after this order was passed. My lord will kindly look at the order dated.
I have an order. You tell me the date of the
8th
order.
September.
Yes.
8th September order. 5th September, my lord, I
Yes,
stand
yes.
corrected. 5th September
Who
order.
are you?
My lord, I am the mother. I am
Yes.
the mother, the
Who is
marriage,
having custody? Your,
the father is having the custody. The
yes.
father surreptitiously moved the child to Bangalore without informing me from Calcutta, from his ordinary residence. My lord, I had taken out an application for interim custody before the district judge. The district judge passed an order which was unworkable. Assailing that, I come before the revision court. The revision court heard the matter on several occasions. And my lord, on 5th September, I made a prayer, oral prayer before Justice Basu to allow me to meet the child at Bangalore for his birthday on 8th September. Well, the Pandora's box opened after that. Matlab,
No, just a minute. Mr. Yes, আমরা ডেকে দাও, Mr. Yes, পাসওয়ার্ডটা ডেকে দাও। হ্যাঁ, ডেকে দাও। Yes.
Password better, added on 7 and 8.
Yes,
I
order.
missed the list, Manoj. I missed the list.
No, it's all right.
Mr. I have asked Mr.
Says
Bose
come
to also,
forward,
my lord,
not at
join.
your instance, at my instance.
My lord.
For seek clarification from Mr. Doctor.
My lord, I have asked him to join. What he told me, I just called him.
Yes.
My lord, though it's not there in this, my lord, there was, my lord, a complaint lodged with
Where is
Bhatupara
that
police.
complaint?
That's not here, my lord. I have been just forwarded that complaint. I'll just read it out for your lordship. It's of 27th of December 2024. I, Manobendranath Basu of so and so, situated at so and so. Yesterday at 26/12/2024 at about 12 noon, some unknown laborers came on gate number 2 backside of police barrack in Kakinara Para paper mill, started to cementing work of the wall of gate 2 unauthorizedly without consent and authority. The paper mill is surrounded by brick wall fencing and possessed by a Titagore paper mill, which is my client since long time. So I pray to your kind honor, considering the position on behalf of Titagore Enterprise Limited, no unwanted person to enter into the premises or any work should be done.
Mail that, mail that.
I have asked for a copy.
No, no,
my lord.
mail that to my officer. I'll get it here now.
This is
My lord, I also clarified from
respond
you
to that.
why we made
It says come for clarification from the court, sir.
He is there, my lord. Mr. Bose is also there, my lord. I asked him to join.
Yes.
একটু mail ID টা দেবেন?
এই দাও না প্রসেনজিৎ, mail ID টা দাও না. There is a general mail ID for the court. So you can.
That's very convenient, my lord.
No, because I was doing the group 4 matters where you see there are most of them are online. So it is the only means.
Last week we were told, my lord, in course of a hearing before the division bench presided over by Justice Bosak, that the court is, my lord, contemplating to shift to digital.
Yes.
And there would be, like in Delhi High Court, there would be a screen here
Yes.
before the learned judge and 2 screens for the advocates.
Yes.
We cannot across the table, my lord, feed in papers like we do usually. Like
You send it to.
but we can, my lord,
This is
send
recorded.
it to the
So
registry. and
once you do it, Mr. Dotto, this document gets recorded in the file
yes,
that you have sent it. And the requirement that once it, despite being recorded, a paper is lost, that will not happen.
RITAN23@gmail.com. CHC dot পাঠিয়ে দিয়েছি।
আমাদের কপি দিয়ে হবে।
তোমাকে পাঠিয়ে দিচ্ছি এখানে।
WhatsApp করে দেখ তাহলেই হবে।
Your lordship was looking for me.
Mr. Bose is there.
Yes, yes. Let me find.
I told him that we should have, my lord, with a supplementary. It was
Doesn't
prudent
matter.
on our, it should have been, my lord, done, but
The incident happened on 26th of December, 25th of December. There's a general diary on 26th
Sir,
December.
boss, that is not part of the record.
My lord,
And not part of the record, Mr. Bose.
we'll put in a supplementary, my lord, recording.
supplementary if your lordship so wants, but
But you ought to have been part of the record.
how could it read? At the time of filing, it was not. Matter was appearing in your lordship's list since November.
Situation for which the matter was taken up on urgent basis.
Yes, my lord. It's a post-filing event.
Mention this matter, Mr. Bose. You must be
Yes, my
remembered.
lord. Yes, my lord. It's a post-filing event. That's why it was not there.
Fact has to be put on record.
Yes, we'll put in a supplementary affidavit in that case.
We should have, my lord, put in a supplementary. পেয়েছেন দাদা? পড়া যাচ্ছে?
Although this, পড়া দিয়ে দেবে পরে.
I'll give a fresh copy. my lord.
Although this matter was heard yesterday and an order was passed. However, since the factum of the opposite parties interfering with the petitioner's possession and or attempting to demolish the boundary wall of the petitioner
And reconstructing.
was not found on record. This matter was placed in the list under the heading to be mentioned to seek clarification from the petitioner's advocate. First up today, Mr. Dotto, learned advocate representing the petitioner, has placed before this court a complaint dated 27 December 2024 addressed to the inspector in charge, Bhatpara Police Station.
Bhatpara, yes.
Bhatpara Police Station, 24 Parganas North, you would submit that since the aforesaid incident, since the incident recorded in the complaint had occurred subsequent to filing of the revisional application, the same could not be included in the revisional application. Be that as it may, since such document has been placed before the court, the same is taken on record. First, having regard thereto, the order dated 13 January 2025 is recalled and the matter is taken up for consideration afresh. So I'll pass that order. I'll give you the same protection. And Mr. Lahiri, the matter is fixed on
10th of April.
10th of
April.
April.
Great.
Same protection is there for the parties.
Same order will be passed.
Yes.
Yes.
Because
But it's being passed today.
clarification, I'll be passing it today.
Right.
There is no change in circumstance. This was not there. But Mr. Lahiri, since it was not there, I could not have passed the order. But since it is there,
Kindly will see the,
I will hear you on that date entirely.
no, the tenor of the letter. It is not their boundary wall, which what is.
But
which is
something
not
is there on this.
It's their submission. My order is recorded there.
Yes, they have submission.
And my order is recorded that I am in possession. My order is
One
recorded.
one leave, my lord, to put in that supplement.
As prayed for Tolar Dige, as prayed for, leave is granted to Mr. Now, Opuri, taken on record. Mr. Opuri, Mr. Dotto, however, prays for leave to file the aforesaid letter by way of a supplementary affidavit. Full stop. Not necessary, it is there.
On record. Why mail it is? My order, the last, yesterday order was uploaded.
No, no, no,
No.
it was not.
That is why I've recorded unsigned order. I have not signed the order.
I understand.
In fact,
While
this,
checking it, unfortunately, it came to my notice.
I'm
The
grateful Lordship
same
has
order
kept
will
it
be
as to
passed,
be
but-
mentioned.
I'll just record whatever is there in the there in that letter. I'll record it, and protection I'm giving to both the parties. Same protection.
Grateful.
Status quo as to position will be continued.
And my order is recorded that I
But
am
if
in
it was not there, then I would not have continued this.
Possibly, yes. But
Yeah.
it's
But
Say fast,
naturally
my lord,
not,
also this
certainly not on this ground. If this letter communication was not there.
No, without that communication, I would not have mentioned the matter before your lordship.
I understand, Mr. Bose, but that was not there.
No, no. Without this incident, I would not have mentioned it because matter was appearing for long.
Checked it. Mr. Bose did
Yes.
not find it either in the records before the trial court or in the petition.
Yes, yes, I appreciate where your lordship is coming from.
Yeah, everything is there, sir. Your orders have not interfered with, sir. Position is status quo as to position.
as on date.
As on date. তাই তো আছে, order টা
হ্যাঁ,
আছে।
that is the order.
Yes, yes, I passed that order. Yes. Okay. Recall হলো, ওই তো ছিল, মাথায় ছিল। Yes, call the next matter.
Lord, I am for the petitioner. Lord, it's a case of a lady. Lord, the fight between brother and sister.
Yes, sir. Which matter are you waiting for? Very well, sir. Yes, sir. Very well, sir.
Lord, what happened, Lord?
They have lost weight, sir.
The property belonged to mother. Lord, mother executed a will and gave it to the unmarried daughter. Lord, brother is a high official of Bhel.
Brother is an
Office of high official of Bhel company.
okay, Vale. Yes, yes.
Bhel. And he has
BHEL.
Yes.
Yes.
Lord, he has a flat in the Bhel cooperative. But what happened? He lost his wife. Premature death of wife. He came with the child to the daughter, to the sister, and was residing there with the sister. Now the child has grown up. Now he has filed a suit for declare that he is a bona fide occupier of the property, and got an injunction. And 5 criminal cases have been filed that against the sister. The injunction order was passed as back as 10th August 2022.
Who are you? You are the sister.
I am the sister, the defendant in the suit. Lord, got an interim order.
You are residing with in a brother's property.
My property. Brother has been allowed. After death of his premature death of his wife, he came with the Lord minor child to look for looking after.
Ancestral property.
The property belonged to my mother.
Your mother means your, so his mother as well.
Yes. Mother, Lord, left a will. Bequeathed the property in my favor. It will has been probated with the consent of the brother. Thereafter, the brother, Lord, when came with the minor child, I looked after him. He had grown up. Now, Lord, they have filed a suit against me for declaration to the effect that he is a bona fide occupier. And Lord, 5 criminal cases have been filed against me. And Lord, ad interim order of injunction was passed on 10th August 2022. Interim order is being extended day to day. I filed my written objection, injunction has not been heard. And Lord, the written statement within time with counterclaim has not yet been accepted. Dates are being given. That's
Sir, it is
yes,
better.
Lord.
It is better,
That's
sir.
why, Lord, I am saying.
Having heard Mr. Ghosh, learned advocate representing the petitioner, let a copy of the divisional application be served on the opposite party. File affidavit of service on the returnable debt. Yes.
Great.
Yes. Call the next matter.
Item number 12. Your Lordship, in this matter, I am for the petitioner Lordship led by Mr. Parthopratim Roy Lordship.
You will not do it.
Yes, sure. Because he is engaged in another court.
This is the only chance. Yes,
Yes,
sir.
Lordship,
Move
because-
it. Move it. Move it.
Lordship, defendant is
For
the
the opposite party.
Yeah, caveat.
Yes, sir.
caveat.
Yes.
Defendant is the petitioner. Now, Lordship, the plaintiff filed the suit, status quo was granted. Challenging that Lordship,
Suit for declaration.
suit for declaration to be the absolute owner without making any other party as party, without any declaration praying for that he is the one of the co-sharer. There was no prayer regarding Lordship partition. Sought for Lordship injunction against the other co-sharer.
Very well.
Now Lordship trial court Lordship treating the same suit Lordship without any though there was no prayer, pass an order of Lordship status quo. Lordship against that Lordship the defendant petitioner filed an appeal. Appeal was allowed Lordship, but directed the defendant to Lordship. I do not know Lordship whether this is a copy or paste Lordship. Directed the defendant not to disturb the peaceful possession of the plaintiff. While Lordship from the schedule of the suit it will be revealed Lordship there is no demarcation, only vague schedule has been mentioned.
You are in possession of certain
I am-
portions
I
of
am
the
in-
property. He is in
I am
possession
the-
of the
I am in the
certain portions
largest
of the
share.
property.
No partition is done till date.
No,
No
partition is
partition.
there. What wrong in the
That-
order passed of status quo? What is wrong, so wrong in the order passed by status quo? On the contrary, it should be altered to status quo as regards nature, character, and possession also.
Position. Because Lordship, I am cultivating the land. At the time of mentioning, I have mentioned that I have cultivated the land.
Yes,
And Lordship, I am in possession. The dependent after they are.
Also in possession.
that will not interfere with your right to
No.
carry out
But
harvest
Lordship,
land.
the order of the appeal court, Lordship, we have came before your Lordship challenging the order of the learned appellate
Where is
court.
the order
Lordship.
passed by the trial court?
It is Lordship at.
Where is the certified copy of the order passed by the trial court?
It is Lordship. It is next Lordship. Kindly.
Certified copy, certified copy.
No, certified copy.
Sorry, sir.
Lordship.
Is a miscellaneous
Yes,
appeal you're
Yes,
challenging?
Lordship.
Where
We
is the
have to
certified
annex
copy,
Lordship
sir?
both the certified copy Lordship.
Where is that?
But Lordship, we have annexed Lordship the order.
Yes.
Photostat copy. We will Lordship kindly give us liberty. We will Lordship by way of supplementary affidavit. We will file the Lordship. Now
I
Lordship,
uh,
will modify the order just.
You also kindly consider.
Because
No,
Lordship,
Arif,
now
you do not also interfere with his position. It is an unpartitioned problem.
because
I have no
taking
problem to interfere with their position. Let them do not interfere in my position, nothing.
So order of status quo as regards position.
because Lordship
That was the exact
Because
order passed
Lordship,
by the other trial. That was the exact order. Kindly turns to the.
because Lordship if they what was the prayer Lordship before the learned appellate court, if specific prayer in the suit has not been mentioned, in respect of that prayer Lordship injunction cannot be prayed for.
And you make a counter claim
Yes.
for partition.
Lordship, in the application Lordship, we have stated that these are the
Have you made a counter claim for partition?
counterclaim. I have stated Lordship that this
What is your counter claim?
that these are the parties Lordship. Kindly consider Lordship page 61 once Lordship.
What is your counter claim?
Page 63. This is nutshell of the Lordship story. Your Lordship will find Lordship Hajar Ali Khan.
Hazar Ali Khan.
Hajar
Yes.
Ali Khan. Lordship, the property originally belongs to Hajar Ali Khan. Now, Lordship, he died, Lordship, leaving behind 4 sons.
Who are you?
I am, Lordship, claiming through Lordship Yaqub Ali. And Lordship, they claiming through Lordship that the Nekjan Bibi. treating that the plaintiff lordship, the next gen BP is the owner of the entire suit property. They prayed for lordship absolute ownership and prayed for the injunction against the co-sharer, which is not maintainable. Declaration, partition has not been lordship prayed for.
You are not also praying for partition.
Yes, lordship, in the because lordship, if defect is not
Are you
cured,
interested to pray for partition? Make up your
no
mind.
prayer, I can lordship show from
Make up your mind. I can always convert that suit now.
that I.
You can convert that
Yes,
suit
yes.
now. Multiplicity or proceedings will not help.
For the order lordship of the learned appellate court lordship, we have
I'll
cultivated.
modify it.
Yes, good.
The petitioner claims that one
for disposing the lordship injunction
In
application.
fact, already has been disposed of.
Yes, disposed of.
It is made clear that in the event the petitioner does not take any step, opposite parties do not take any steps, do not take any steps. Do not take any steps for converting the suit to a partition suit. For seeking, do not take any steps for effecting partition of the suit property by amending the plaint. The petitioner shall be at liberty to apply before the trial court for vacating the aforesaid interim order.
Grateful, lordship.
Affidavit of service filed in court is taken on record. What more, sir? You go and file a.
I have no objection.
Yes, yes.
Satisfied.
And he or should be satisfied. Partition suit at the end of the day.
Partition suit, lordship, most of the lordship, Koshiara has been left out. Only one son.
Now file it. Proceed there. Next.
Yes, my lord.
Yes, sir. What is the matter?
Yes. Matter is, my lord, the against, my lord, execution it is under, my lord, Consumer Protection Act. Now, my lord, order is impugned. Order is at last annexure, where, my lord, my application was rejected. Well, I tell your lordship the background of the case. Why I have come up before your lordship, because, my lord, not going before, after exhausting the forum of National Commission, without going to Supreme Court, why I have come up? Because, my lord, there is a judgment of Supreme Court that we should approach
the jurisdictional court. Show me that judgment.
My lord. My judgment is thou, judge.
So serve them and come. I'll hear you.
My lord, that's true.
Judgment at the
But,
other
my lord,
side.
I am afraid.
What interim order you are
My
saying?
lord, I am only, my lord, execution proceeding should be stayed because
Next week I'll place it. Serve them and come.
my lord,
Serve them and come. Next week, can you serve?
a number of parties are there. Because some private parties are there.
I'll give you 2 weeks. Serve and come.
Your lordship, my lord, kindly protect to some extent. After all,
After hearing them, I'll protect you. Nothing will happen. The matter is pending before the court now. If you find any difficulty,
my lord, what has happened?
what they are
What
trying
has
to
happened, my
execute?
lord,
What they are
only
trying to execute?
Only I will draw your lordship's attention to 2 pages.
Yes.
Page 36, 39, 30, 40. 39, 40.
So what they are trying to execute? Just tell me that.
Warrant of arrest, 39, 40.
Where?
Right,
Which page? 40.
39, 40. First one, 39. My lord, top one, order number 7. My lord has got it, my lord. Yes, Dr. Sunil Bombochari has appeared and submitted that he is no way related to the company for long period, and he is ex-vice chancellor NBU, North Bengal University. Entire company run by Joydev Garai. So, considering the above fact, recall warrant of arrest against judgment dated to Mr. Sunil Bombochari, Dr. Bombochari, as he is not liable to pay anything, and as such, JDR number 2 is discharged from his liability. Recall warrant of arrest from PS in respect of pending warrant of arrest against Dr. Sunil Bombochari. Next page.
Can he do this? Warrant of arrest? Perhaps.
My lord, my lord, this was ultimately recalled.
Anyway, there should be some
protection.
No, that is all right. I will protect you. Where is the parent order? Page 37.
37. 39. No, 37.
You
Sorry.
did not appear. Everything is ex parte, sir.
37.
Everything is.
Well, only I am playing, man. Only two
Ex-party.
things I am submitting before lordship. I was not connected with Amazon Capital Limited. In form number 32, it was not mentioned, my lord. My name
Why
was
did you not appear?
My lord,
Why did you not appear before the court?
I did not get the notice. I have stated in my petition that I was staying at Durgapur. My house in Calcutta was locked, and because I left for other job. Now, my lord, I was actually related with, my lord, Amazon Agro Products Limited. I was once upon a time, I was the director of that. But I was not in any way connected, and my lord SEBI will paste a follow. 121, Lordship, kindly look at 121. This is the list of SEBI. There, your Lordship won't find my name. And also, Lordship, kindly look at 141. Metropolitan Stock Exchange. There also, your Lordship won't find my name. Under the heading, my lord, Amazon Capital Limited, my lord has got it, my lord. Directors, Lordship won't find my name. And also in form number 32, your Lordship won't find my name. But I have been tagged, and later on, this delay can be condoned, my lord, on the ground of, my lord, your Lordship knows, my lord, there are a series of judgment.
But the order has been passed long back.
Even then, my lord, if, my lord, 1200
You serve
pages,
and come.
at least, my lord, for
No,
the
this
time
is
being,
all 2016.
my lord, I tell your Lordship,
No,
for the
2000
time being, your Lordship can protect to this extent.
No, this order is also the order number 7, Mr.
My lord.
Sir, that is also long back.
No, order number 7.
2016.
That is in my favor. 39.
16, sir. Today we are in the year 2025, sir.
No, your Lordship kindly see, my lord.
Sir,
39, page 39, it was recalled. Warrant of arrest was recalled.
Maybe.
Now, appellate authority has said, no, it can't be done. They can't do it. This is, my lord, at page 41. 42. Ordering portion is at 42.
All this 2018.
My lord, because my lord,
you serve and come. Only thing, you serve and come.
my lord, only after,
how soon can you serve? Next week I'll take it up. You serve and come. It's a long time, sir. It's been a very long time. You serve and come, I'll hear them. Ex parte is not fair. After 4-5 years, I'll pass an order. Please understand, sir. You serve and come. Let a copy of the revisional application be served on the opposite parties. List this matter for further consideration under the same heading. Sir, you tell me when you can complete it. I'll immediately place it. Next week you want, I'll place it next week, or the week thereafter, I'll place
next
it.
week. Next week.
Tuesday.
Wednesday or Thursday. Wednesday or Thursday.
Thursday is, we have a holiday.
Oh, Wednesday?
22nd.
22nd?
22nd.
By this time, I will serve.
Yes, serve it. Petition is directed to file affidavit of service on the return. They can you petition search. Yes, sir, come back.
Get.
Call the next matter. Hey, I have to take a good boy. Monthly শুরু হয়ে যাবে monthly দেখো monthly ডাকো 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 about একটু দেখো লোক কি
number 61.
But this is a suit of 1998. But eviction suit governed by the West Bengal Premises Claims Act 1956. Because at the relevant point of time, my lord, the 1981 Act, the Chica-tenanted property, my lord, 1981 Act was in operation. And my lord, in view of section, my lord, (1981) Act, Section 9. Thika tenants and Bharatias to be governed by West Bengal Act 1956. The monthly and other periodical tenancies of Bharatias in respect of structure occupied by them on payment of rents to the Thika tenants shall with effect from the date of coming into force of this act be governed by the provisions of West Bengal Premises Tenancy Act 1956 in all matters coming within the purview of the said act and for the purpose.
Sir, you are a Bharatiya.
Malad,
You are a Bharatiya.
I am Bharati. So, Malad, this suit Malad not under the Malad Premises Tenancy Act 1997 or under the West Bengal Thika Tenancy Act. This suit, Malad, is a Malad is of 1998. Kindly have a look at the Malad the plain. Malad, I have annexed this. Malad, it is Malad at page Malad 8. This is a suit of 1998. At the relevant point of time, 1981 Act was in operation. So this suit is governed by the 1956 Act. West Bengal.
When did the 1997 Act come into play?
Malad, on 10 July 2001. 10 July 2001. Malad, I have.
Very good.
So, Malad, this suit was filed, Malad, in 1998, and this suit is governed by the West Bengal Premises Tenancy Act 1956. And, Malad, question was popped up, Malad, on earlier occasion, Malad, whether, Malad, I can pray for repair before the civil court or not. Malad, I have two options. Malad, I can, Malad, straight away go to the Malad Thika controller, call Malad repair by filing Malad independent proceedings, or Malad, I can come the pending suit before the civil court.
Second part. First part is the trial controller has the power.
Yes, sir.
Thou. This is with regard to 1997 Act. This is with regard to the 1997 Act.
1956 Act and 1997 Act are similar. Malad.
হ্যাঁ ঠিকা টেন্সি একটা হতো নতুন বইটা দিলেও হবে ওতেই আছে সব আছে
So-called repeal and saving clause.
Here the question that fell for consideration was whether the controller, not the Thika controller,
Controller. 1956 Act.
had the power.
Yes.
There the court said the remedy is an additional one.
Yes.
You are now relying on the provisions of the Calcutta Thika Tenancy Act 1981.
19.
Yes. Repeal and saving, you want to show which repeal and saving of what?
Kindly have this section 27 of the West Bengal Premises Thika Tenancy Requisition and Regulation Act.
Yes.
Section 27, my lord.
Yes.
With effect on the date of commencement of this act, the Kolkata Thika and other tenancies and lands Acquisition and Regulation Act 1981 shall stand repealed. Malad, I am governed by Malad 2D. Affect, Malad, shall not affect, this repeal shall not affect any investigation, legal proceeding or remedy in respect of any such right, privilege, obligation.
So you are trying to say of proceedings initiated under the Calcutta Thika Tenancy Act will continue even after the West Bengal Thika Tenancy Act has come in force. Are you aware of the law background in the law which led to presentation of this act, that is West Bengal Thika Tenancy Acquisition and Regulation Act 2001?
1997 Act.
Today we are on the question whether after coming into force of the West Bengal Thika Tenancy Acquisition and Regulation Act 2001, the provisions contained in the Calcutta Thika
Repeal and saving clause.
Acquisition and Regulation Act 1981 can be made applicable. Yes.
No, by repeal and saving clause, I am governed by 1956 Act. And this suit has been filed, and now the suit is pending and it is governed under the 1956 Act. Kindly have a look at section 45 of the 1997 Act. Tenancy Act.
Very well. What the learned judge did, let's come to this first.
Section 45, 1 and 2,
What the learned judge did here, what was order was passed.
So learned court below, was to reject my application,
Hmm.
on the ground,
There is nothing. There is nothing.
In August,
What will the court find out? Why are you taking me so many provisions? See the order. Today there is nothing. What is the use of local inspection? The court will go there and find out there is nothing. So, Mr. Haldar, you have to be conscious what application you can move.
in August 2018, I took out this application. My application for repair, very nominal, clear, kindly have a look at page.
Today there is nothing. Today.
By this time, this application was filed in August 2018. Commission was held in 2022. By this time, that was the Amphan cyclone. And this.
So you have to take different steps. This application will not help you.
By the act of the court, litigant should not suffer.
What will the court do? Now resurrect your building. Please understand, Mr. Haldar. Please understand. Don't say all these things.
This is a two side Dolma Bada and two side brick build wall.
Nothing remains. After that cyclone Amphan, it is all on the ground.
That does not evaporate my tenancy right. And why
for that no local inspection can be granted. For that no local inspection can be granted to ascertain whether at some point of time there was something on the land.
No. Local inspection done.
Yes.
Report says there are remnants of the structure there. If that is there, I am entitled to get the order of repair.
Where is your report?
Kindly have a look at. The relevant portion at page 40. This is a handwritten report filed before the learned court. I applied for certified copy. In the middle portion, that on the eastern side there is no wall. On the western side there is a brick wall. On the southern side there exists some broken tins. And
where is this place?
Place.
Where is this place? You're saying Thika?
Maniktola, Mudaripukul Road.
And an effect of Maniktola, this was not registered as Heart. What is your address? You are saying Thika? What is your address?
I am not saying Thika.
What is your address?
They are saying Thika.
What is your address?
I'm telling schedule of the property.
Yes, show me. Where is the plane?
Page 13, schedule of the property.
Yes.
Page 13,
Yes.
All that one room made of pakka walls.
Any address?
T by 31 by G, Biplobi Baringos Soroni. Formally 31 Mudaripukul Road.
Where have they stated that this is Thika? In the plaint? Where have they stated this is Thika?
Paragraph 1 that the plaintiff is owner of premises number T by 31 by G, Biplobi Baringos Soroni, formerly 31 Mudaripukul Road. PS Maniktola, Calcutta 67. and the defendant was a monthly bharatiya.
I see.
Under the plaintiff, in respect of one room made of pakka wall in two sides,
Having not been learned advocate for the petitioner, let a copy of the revision application.
I will be remediless. Kindly consider my petition.
You serve and come, you want.
I am serving, my lord, but kindly stay the for the time
No,
being.
no, I will not stay.
If by this time, my lord, suit is
I am not
disposed of,
satisfied with, I want to hear their, ওখানে আরেকবার পড়ো, ওখানে the petition is related to serve a copy of the revisional application on the opposite party to ascertain the stand of the opposite parties. Is this matter for further consider, is this matter under the heading returnable motion? Can you serve in this month?
my lord,
Huh?
my lord.
Let this matter be taken up for further consideration on the same heading on 28th of January 2025. The petition is directed to file affidavit of service on the returnable date. Just a minute. Since an accommodation has been. হ্যাঁ দিয়েছে তো এটা, হ্যাঁ কত থেকে কত আছে আমাদের, হ্যাঁ ভালো আছে, হ্যাঁ হ্যাঁ। Since an accommodation has been paid for on behalf of the learned advocate for the petitioners on the ground
But if it could be taken on 30th,
no, it's not possible this side. It's very tough. Mr. Rasgupta is very tough. I'll be there on. You come, I'll accommodate you for.
But if it could be on the 5th or 6th, in the first week of February.
I've already fixed these matters, and your matter will take some time, certainly.
Well, in that case, Lordship will keep it on 13th.
Yes.
13th, if it could be taken up.
13th,
But this would require not much time.
Mark 13th.
13th.
Mark 13th.
13th.
Number 9.
Item number? None appears for the parties. No accommodation has been sought for in view thereof. Will this matter be dismissed for different? Oh, no, 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 no. Dismiss for default.
Item number 93.
Well, I'll for the petition. The petitioner plaintiff filed an ejectment suit and suit for permanent injunction. Injunction was granted. Prior filing of the suit, the plaintiff, my lord, the defendant opposite party also filed another application for injunction, permanent injunction, mandatory injunction, but that was not granted. Appraising such fact, the plaintiff, the defendant opposite party, filed one after another 151 application. In 151 application, my lord, your lordship kind.
Yes.
My lord, may I have your lordship kind attention to the order of
You're
injunction?
challenging the order date is 9th February 2024.
Yes, my lord. Yes, my lord. 151 order was allowed, but prior filing of this 151, there are 4 151 application.
Will not supply water, electricity.
No, my lord, I am not supposed to because I am not residing there, and water is
Who
there.
are you?
Water. I am the landlord, my lord.
So you are not supposed to.
I reside at separate. I reside at separate premises, my lord.
Does not matter where you reside. This is your property.
Yes, my lord. Yes.
Water connection is there.
Yes, my lord.
Water connection was there.
Yes, my lord.
You have disconnected the water connection.
No, no, my lord. I have not disconnected.
Then what have you done?
No, my lord. Kindly comes to page.
You have filed the suit, ejectment suit.
Ejectment suit. I have not disconnected. The CSC had disconnected the line because of non-payment of the CSC bill. CSC had disconnected. That is also mentioned in the order. Lord, you kindly come.
Fill in this meter running. I'll grant them liberty to take separate electricity connection here and now.
Yes, my lord.
In your application, I'll grant them to take separate electricity
Lord, you
connection.
kindly appreciate.
Why will I appreciate? Sir, you cannot disconnect electricity and water.
My lord, I have not disconnected. In respect of the injunction, in respect of the electricity connection, specific prayer of the defendant was turned down. Lordship kindly comes to that order. Thereafter, your lordship passes the order. Lordship kindly comes to page 98. Lordship kindly comes page 98, annexure P4. I have not disconnected, lordship. That is my submission. Suppressing such facts, the defendant opposite party filed one application.
Existing supply of
Lordship kindly comes to
No, that your lordship can, but lordship kindly comes to page 100. I have not disconnected. This electricity was disconnected for non-payment of bill.
I'll come to this.
And I'm grateful.
Meter in the name of the defendant.
Yes, madam.
Meter in the name of the defendant.
No.
Whose name?
Erstwhile, the owner, who is now deceased. Lordship, kindly consider.
Yes, come.
Item number 94.
My lord, in this matter, Mr. Probal Kumar Mukherjee is appearing for the applicant. My lord, he has his legs on code number
For
60.
the opposite party number
Well,
5, my
kindly-
lord, this revisional application has become infructuous because the case is disposed of.
No, my lord, we have filed an appeal, my lord. We have filed an appeal.
Yes, they have filed an appeal against the dismissal of the case before the cooperative tribunal.
My lord, kindly make it not today, my lord.
Since an accommodation has been sought for on behalf of the petitioner.
93 though.
Yes.
Item number 95.
None appears dismissed. None appears for the petitioner. No accommodation has been sought for. In view thereof, let this revisional application be dismissed.
Item number 96.
This is an application for my lord, expeditious hearing of a partition suit, my lord. The suit was filed on 12th April 2022. There was a 22 parties, defendants. My lord, WS was filed on 10th August 2022 along with a counterclaim by the defendant number 1. And since then, thereafter on 28th of February, the injunction application was disposed of.
Pleadings are complete.
Yes, my lord.
Pleadings are complete. All the parties have filed. All the
No, my lord, thereafter, the defendant number, except defendant number 1, court was directed to, Lenat court, trial court directed to take steps against that parties. They are not the owner of the property. But since then, it is at the stage, same stage, my lord, since 28 February 2023, for taking steps against the rest 21.
The plaintiff prays for expeditious disposal of the title suit number 30.
'97.
So, there is no caveat, my lord. You have served us a notice, my lord. I'm appealing for the opposite party bank.
In this matter, may I serve the lordship, the advocate on record in this matter informed me that he could not come to court today.
This action of the bank, my lord. I don't know.
Since an accommodation has been sought for on behalf of the petitioner, let this matter go out of the list. Yes.
Item
number 98.
None appears dismissed.
97.
Item number 99.
Unappears dismissed.
Item number 100.
Same order.
Madam, for the respondent, my lord. Grateful.
Item number 101.
Dismissed.
Item number 102.
Happy on behalf of the petitioner. The petitioner filed the landed court below order 7 rule 11. In order to dismiss the state application on the ground that the reason for that order 7 rule 11 will be dismissed, no cause of action is present in this petition.
What is your ground for dismissal of the for rejection of the plaint?
The petitioner not disclosed their the cause of action, my lord.
Where is the plaint? Where is the plaint?
Then, my lord, page number 13, my lord.
Yes. Yes.
No, not disclose the cause of action.
Which paragraph?
The petition, paragraph number, the order portion,
Where is your application? Order 7 rule 11.
not annexed there.
Challenging the order dated
103.
103, my lord, I am appearing on behalf of the plaintiff petitioner. My lord, suit for eviction of a tenant. My lord.
Yes.
My lord, suit filed and the defendant opposite parties, my lord, appeared before the landed court below, my lord, and filed on appeared on
Yes.
16th April 2019.
Yes.
My lord, thereafter, my lord, he filed written statement on 16th August 2019. Thereafter, he filed on application under under section 7.1
When did
and
you serve
7.2.
the summons?
Yes, my lord.
When was the summons served?
My lord, summon was served. My lord, that has not been stated. But my lord, he appeared.
You're challenging the order date 16th August 2019?
Yes, my lord.
16th August 2019?
2019. My lord, 7.
In the year 2024?
Yes, my lord, I have stated, my lord, why the petitioner.
What is the stage of the suit?
Stage of the suit, my lord, written statement filed when an issue has not been taken.
I'll expedite the suit.
My lord, not only that, my lord, my lord, because of that, my lord,
Too late in the day.
my lord, I have stated what is the reason, my lord. My lord, kindly consider, my lord, there are several judgments passed by our coordinate bench of our High Court.
After 4 years, you've woken up from your slumber and come before this court.
My lord, kindly,
As and by an afterthought.
my lord, kindly consider, my lord.
You could not disclose when the summons was served.
My lord, kindly consider. I have stated in paragraph, my lord.
Yes.
My lord, what page number 8, paragraph number 18. My lord, that the petitioner states that before that, my lord, page number 7, paragraph number 70. My lord, that the petitioner states that after passing the order impugned, the petitioner met with the learned advocate Mr. Shiva Prasad De in the month of September 2019, who was the regular.
Paragraph?
Paragraph number 17, my lord. Page number 7. What is, my lord?
Yes.
That the petitioner states that after passing the order impugned, the petitioner met with the learned advocate Mr. Shiva Prasad De in the month of September 2019, who was the regular practitioner before the Howrah Court. And on that day, one learned advocate of the Honorable High Court, Calcutta, was present at his chamber situated at Howrah Court. And according to the instruction of the learned advocate, Mr. Shiva Prasad De, the petitioner handed over all the relevant papers.
And it will not cut ice, sir. Forget all this.
My lord,
After 4 years, I'll not permit.
my lord, kindly consider, my lord, notice.
Why are you challenging?
My lord, I have stated why the petitioner was.
Why are you challenging the order? On what ground?
My lord, ground is that, my lord, the settled law, my lord, according to the statute, my lord, the specific time is 1 year, 1 month from the date of appearance or from service of summons. My lord, if your lordship kindly come to the come to section 7.1 of the Premises Tenancy Act for a moment, my lord.
You ask for review, withdraw it, go before the review. Sir, I will not allow it.
My lord, if my lord kindly consider the judgment, my lord, past 7.
Are please understand, after 6 years you have come.
My lord,
Go and apply for review. If it is not, go and apply for review.
your lordship has enough.
No, I will
My
not.
lord,
I will not.
My lord, kindly consider, my lord. My lord, due to the sudden demise of the learned advocate appearing before the learned court below, my lord, the petitioner was unable to come before your lordship, my lord, within time. My lord, there is delay in filing 78 days. If your lordship kindly see, your lordship knows very well, my lord. My lord, the 7172 should be filed within 1 month from the date.
I
of
will provide
your
that. This
lordship
will be
knows very
decided as a preliminary issue in the suit.
My lord, kindly consider, my lord.
Preliminary issue in the suit. Preliminary issue in the suit, so that the defense can be struck off.
Yes, my lord, that is correct, my lord. But your lordship, my lord,
I cannot.
the impugned order
cannot.
is
No.
completely, my lord, illegal and bad in law, my lord. My lord, kindly consider. If your lordship, I have some judgment, my lord. If your lordship kindly come.
Challenging the order dated 16th August. point of
Grateful, Your Lordship.
the delay in filing the revisional application is kept open to be decided at the time of at the time of final hearing. Yes,
Order 711 annex matter,
Advocate Andre.
page number 25, my lord.
it is there.
Yes, ma'am.
দেখি দাও আগেটা দাও।
Sir,
What are you doing, sir? You are not showing the code.
sorry, my lord.
দেখি দাও।
Right up. Page
তুমি নিয়েছিলে তো করে দিচ্ছি। দেখি দাও ওটা আরেকবার দাও।
এটা হলো 102।
ডিসপোজ হয়ে গেছে গো আউট হয়েছে দাও ওই অর্ডার রিকল করে নাও। ইয়েস, which page?
Page number 25, my lord.
Page number?
25.
What prevented you from showing this?
I could find, my lord.
Challenging the order dated
Item number 104.
My lord, I have heard the petition, my lord. My lord, this application has been filed against my lord, the order dated 21st February 2024, passed in my lord, title, passed by the learned civil judge unit division, Uluberia, my lord. My lord, the case is that, my lord, the plaintiff, the petitioner is the owner in respect of a plot of land at measuring, my lord, 12 decibel. But, my lord, the disputes,
Your application under Order 7, Rule 10.
my lord, I'm
Come to that, sir. What is the application under Order 7, Rule 11? Why are you taking me to the entire history of the case?
My lord, a suit plot is, my lord, only 2 decibels.
Yes.
My lord, the assessment which has been made by the plaintiff is, my lord, below 60,000, my lord. But and in that regard, my lord, the defendant means the opposite party herein filed an applications, thereby raising objections that the suit value.
Valuation of the suit.
Yes, my lord.
Sir, you know what to do for a valuation. For that Order 7, Rule 11 will not 10 will not go, sir.
My lord.
Yes. Yes, continue, sir.
My lord, the dispute is only, my lord, only 600 square feet, my lord.
I need not advise you what to do, sir. You know better, sir. We advise yourself, sir.
My lord, upon considering, my lord, the application as well as the objections which has been raised by the petitioners in the trial court passed an order thereby giving directions for inquiry, my lord. My lord, inquiry. My lord, I have no objections, my lord, but in that order, my lord, no portion, in respect of which portion the inquiry is to be conducted, that has not been mentioned, my lord.
Not necessary, sir.
My lord, I
not necessary, sir.
My lord, kindly see, my lord, the order in view, my lord.
Yes. Yes, show me. I'm on that.
Today is fixed for further hearing of the petition under order 7 Rule 10 of the CPC for return of the plain together with order 14 Rule 2 of CPC. Both parties file Hajira. Plaintiff also filed written objections against the application order 7 Rule 10. Let the same be kept with the record. Now the petition under petition dated 4/1/2024. Only to that extent, my lord. Kindly
challenging the order dated ব্যাস 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 ব্যাস। আচ্ছা, ঠিক আছে কন্টিনিউ হবে কি কাম ব্যাক বইটা আনো বইটা আনো আর আমি পরের লোককে দিয়ে দেবো বুঝতে পারলে? না 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 লাগবে না। আচ্ছা তুমি একবার এসে এটা নিয়ে চলে যাও ঠিক আছে? দুটো পাঁচটা চলে যাও পাঁচশো থেকে come at 2. I'll continue this and finish it off. দেখিনি। হ্যাঁ, ইয়েস, কোথায় বলেছি কতটা? So it is element ordinarily the valuation This is not called for. I'm not interfered. I've recorded how it's to be done. 7, 4B
Yes.
and 7, 6 in respect of Schedule C property. Nothing more. You got what you wanted, but no interference. Yes, call the next matter.
Lordship, my learned senior who is appearing
Yes.
behalf of the petitioner is suffering from a high fever, praying for not this week. Gratefully.
Since an accommodation has been sought for on behalf of the petitioner, file though. Let this matter go out of the list. Yes.
Grateful.
Next. None appears for the parties. No accommodation has been sought for in view thereof. That this matter be dismissed for default. Yes.
After the petitioner plea for not today.
Yes, since an accommodation has been sought for on behalf of the petitioner, let this matter go out of the list. None appears. No accommodation has been sought for in view thereof. Let this matter be dismissed for default. Yes, same order. Same order.
Ashif, I am for the petitioner. Ashif, petitioner is defended in a judgment suit. Petitioner is a tenant for a long time. Ashif, petitioner is aged about 73 years old. What happened after appearance and filing a written statement? Her application for 7-1 was allowed. The petitioner could not deposit the area rent and current rent in terms of the order of the landed court. Therefore, petitioner filed an application under section 151 of the CPC that there was rejected. Is on 16/1/2023. What happened? Petitioner preferred an appeal before the landed additional court, GCX court lawsuit. However, it was subsequently withdrawn. If you kindly consider that.
What will I consider? Law is against you, sir. What will I consider? You're very well aware. You want to place it, I'll dismiss with costs. Unless you show you have a cogent ground.
Cause was definitely there, but medical certificate.
I cannot help you. Law is very clear. You want to press it, I will have to dismiss it with cost. You consider what you want to do. Then withdraw it. Since when the petitioner does not want to press the instant application, let the same be dismissed as withdrawn. I cannot help you, sir. You are know the law, sir. Outer time limit is there once. After 7-2, once determination. Here 7-1. Everything is gone. Your defense has been struck out. 7C order is there. Dago. Your is 111, item number 111. Yes, 112.
Item number 112.
None appears in support of the revisional application. No accommodation has been sought for. In view thereof, let this matter be dismissed for the court.
Item number 113.
Well, I am appearing on behalf of the petitioner, my lord. Petitioner wife. Opposite party is the husband of the petitioner. My petitioner husband now is living separately, my lord. And petitioner's husband is paying 3,000 monthly maintenance to the wife. Even the petitioner filed a petition under the Ward and Ward and Guardianship Act before the learned court.
Guardianship and Wards Act.
Guardianship and Wards Act before the lower court below for meeting her minor child once of a month. Petitioner made objection of this application, but lower court will allow this petition. Then petitioner again file an application for modification of the order. He will meet with her minor child for 2 times on a month. The lower court will allow the petition in spite of objection filed by the petitioner.
What is the objection?
Objection is, my lord.
He will not meet the father.
No, my lord. Petitioner, it is submitted by the consider for that the minor child on meeting with the father feels sick and suffered mental pain. However, increasing visiting spell for twice a month in place of once a month might disturb.
So why once a month, sir? It can be after once 5 years.
Her study.
So it is better it is once 5 years. What do you think? It should be once in 5 years. I'll pass an order of that nature. What do you think?
Month of
Why month, sir?
Once time in the month.
He's feeling sick. It should be once in 5 years or till such time he grows up. Not necessary to meet his father.
Yes, maybe.
I'm shocked how you can move this application.
Well,
and write down such things.
His education will be suffered, my lord. And
by meeting his father.
Other curriculum.
Minor child is girl child or a boy child?
Girl child, my lord.
So she will suffer because she will be meeting her father.
Her study will be.
Study will be sir. Let the custody will be with the father, sir. It will be better.
Others curriculum matter will be.
Now, what shameful applications are being moved? That the mother does not want the girl child to meet the father.
Father made this application.
Take instructions, come back. Not today. Not this week, not this week. Come on Monday, whether you want to move it at all or not.
What instruction, my lord?
Whether you have to move it at all or not. Consider it, sir. You don't want the child to meet the father.
But petitioner is praying to allow her to meet with her child once a month.
Every week, when the High Court is competent to hear out the matter, when the High Court will exercise jurisdiction under Article 227, I will meet the child, and if necessary, I'll provide for every meeting with the father every week.
So you are advising me to withdraw, my lord?
It is no, I'm not advising anything, sir. You consider it and come back next week. I'll take up the matter. I'll hear a matter. 113, I'll hear the matter. Yes, ডাকো। এটা একটু মার্ক করে রেখো তো
14.
মনে করে 113টা লিস্টে মার্ক করে রেখো। I'll take up the matter next week.
Lordship,
Yes.
114 I am appearing for the petition. I am praying for not to.
Since an accommodation has been sought for on behalf of the petitioner, let this matter go out of the list. Yes,
Sir, not go, Lordship, only submission.
go out of the list. Next. In none appears dismissed.
Item 116.
Same.
Item number
Item 117.
Item number 107, Lordship, I am appearing for the petition, Lordship. This instant divisional application has been filed challenging an order passed under proceeding filed under section 36 of the Arbitration Act, Lordship. The similar 34 matter is before your Lordship, and your Lordship was pleased to fix it in the month list of February, Lordship. I am led by Mr. Shonok Shengupta, Lordship. Can be fixed in the month.
36.
No, 36. This is the 30 rejection of my. I've challenged the maintainability of the 36 Arbitration Act on the ground of unilateral appointment of the arbitrator. The 36 of section 36 of the Arbitration and Conciliation Act proceedings was challenged on my part on the ground that the arbitrator was appointed unilaterally and the arbitrator lacks inherent jurisdiction. And Lordship, similar 34 was filed earlier, which is challenging the veracity of the arbitral award, which is also filed before your Lordship, and your Lordship by an order was.
Where the City Civil Court passed that order?
No, City Civil Court not. Your Lordship, this is section 5. My 34 was dismissed for default. My section 34. I have filed an order 9 rule 9 along with section 5. My section 5 was.
That is different altogether.
Yes.
What are you challenging in this application under section 36?
The order which has rejected my ground. I have challenged the maintainability of the section 36 Arbitration Act application, Lordship.
36.
Section 36.
What is 36 of the
Execution of arbitral award, your Lordship.
Yes.
That I have challenged on the ground of maintainability as because the landed arbitrator lacks inherent jurisdiction and on the ground of unilateral appointment of the arbitrator.
Arbitration Act is a complete code in itself.
No, section 36 Arbitration Act. No, Lordship, kindly allows me.
Sorry.
No, kindly allows me for a second, Lordship.
Yes.
Kindly. Section 36 application, Lordship, kindly allows the entire Arbitration Act goes. Only order 21 of the CPC stays. Your Lordship, also I am led by Mr. Shonok Shengupta, Lordship. I have been instructed that he is suffering from high fever. For this reason, Lordship.
Since an accommodation has been sought for on
Next week.
petition, let this matter go out of the list.
If it can be any day next week.
Yes.
Item 118.
None appears. No accommodation is sought for in view thereof. Let this application be dismissed for default.
Item 119.
Same order.
Item 120.
920, I beg to appear for the petitioner, my lord. My lord, under very peculiar and compelling circumstances, I'm here before your lordship. There's an application under section 24, where, my lord, the petitioner is praying before your lordship to move the title execution case from Bonga Subdivisional Court to any court, be it a district, South Chobbish Pargana or North Chobbish. Reason being, my lord, I have categorically pleaded in my paragraph number 2021, my lord, no advocate is appearing for the petitioner.
Where the property is situated?
Property is situated in Bonga, my lord. My lord, I know, my lord. The reason being, my lord, kindly just
of the Civil Procedure Code.
My lord, definitely,
very
my
clear.
lord. My lord, the fact is, my lord, the son of the judge award.
How can the court have jurisdiction to try out? The property is there, understand the situation.
My lord has the power under
That is
Article
different.
227. My lord can Article 227. My lord has the supervision power. My lord, no advocate is appearing for me. Even an advocate who has taken wakalatnama for me is not appearing. My lord, the police help application by the judgment holder has been allowed ex parte despite affidavit wakalatnama has been given. I am the judgment debtor, my lord.
Naturally, sir. So you want to resist execution.
My lord, I am not resisting execution, my lord. I am not resisting execution. I am appearing, my lord. My lord, this is my categorical, my lord, the son of the opposite party number 2 before your lordship is the secretary of the Bar Association over there and also an affluent person politically, my lord. Due to such reason, my lord, be it at Barashat is the district court.
Why will I do that? We will be
My
executed,
lord,
sir.
I am being
Execution.
unrepresented.
Sir, you are only execution, not the
My lord,
decree.
section 47 application has been dismissed for default because nobody
chose
appeared.
not to. Sir, what is the suit for?
My lord, suit was for recovery of khas possession and declaration, my lord. My lord, if I may, my lord, the suit was the current award judgment holder, my lord, has my grandmother, the judgment debtor's grandmother, has bequeathed his right allegedly to the judgment holder, my lord. We have
an application filed under section 24 of the Code of Civil Procedure 19.
My lord, kindly, my lord, they are not on caveat. At least, my lord, for the timing, let them come up with with some reply to your lordship. Till that time, my lord, I'm only humbly praying that the execution be straight.
Transfer of the title execution case number 1 of 2018 pending before the Court of the Learned Civil Judge Junior Division, Bonga, District North.
When my lord is keeping the matter, my lord?
March.
But can it be February, my lord? In the meantime,
Yes,
Bonga,
February.
I can
February.
serve and come back, my lord.
February under the heading motion, part 1.
Grateful, lordship.
Motion,
Grateful,
new motion
lordship.
1, under the heading new motion 1.
Item number 121.
May please your lordship. My lord, the petitioner before your lordship made an application before.
Oh, no, March new motion 1 though. February তো হবে না, March new motion 1. তাহলে 4-10টার মধ্যে থাকবে, 10-12টার মধ্যে হয়ে যাবে। March new motion 1. March new motion 1.
My matter, my lord.
Yes, March new motion 1. New motion 1. So
My lord, whatever, my lord, please.
At the top it will be there.
My lord,
You waited for 9 months. What are you saying?
I shall not pray anymore. Whatever,
Yes.
my lord.
Yes, sir.
My lord, the petitioner before your lordship, the decretal property which was decreed, my lord, that time, my lord, I was not party in the case. I made an application in the execution case, order 1 rule 10(2). That application, my lord, marked at miss case number 39 of 2014. But this miss case was dismissed. Accordingly, my lord, the same was challenged by way of filing the revisional application. My lord, this is the input order before your lordship. The order which was passed on 31st January 2024. My lord, the revisional court, my lord, come to a conclusion that You are the, I am the party in concern, I have possessed the land in question, but although I was not a party in concern. So, my lord, your lordship kindly consider the same. The last
Why did you
paragraph
go
of
there?
the-
Why
Yes,
did
my
you
lord.
go there? Who asked you to go there?
Yes, my lord.
Why did you go there? You are not a party.
Yes, but I am in possession of the property. They have not made party intentionally.
Very well.
As a result, my lord, I made an application. That application was registered Miske such and such. Accordingly, my lord, your lordship knows.
I don't know. You tell me, sir.
No, your lordship knows enough experience, my lord. Then, my lord, order 21, rule 101. I have an independent right. As and when I was not a party, your lordship kindly, order 21, rule 100, your lordship knows. I can make an application and that should be considered by the court below. My lord, in our High Court, my lord, one judgment, my lord, unreported judgment passed by his Lordship Justice my lord, he passed the order, yes, you can make an application and that should be allowed in the as a judgment data.
Allowed.
Allowed.
That
Judgment
should be
data,
allowed.
judgment data.
That should be allowed.
Yes, and
The court, honorable court said that he file an application that will be allowed.
yes, but I'll see.
Sir, how can the court say allowed, sir? Court will consider.
My lord, the facts arise.
Tell me differently. Where is the application under order 21 rule 97? Where is that application? Where is that order passed under order 21 rule 97?
Well, kindly see page.
Where is the certified copy of the order?
I have filed it.
Where is that?
Well, kindly see page 52.
Okay, where is page 52 is which order?
My lord, this is the main order. Which case?
Order 21 rule 97?
Yes. The order which was passed on 31st May 2017.
Yes.
Then the said order was.
So why have you asked for being implemented as a judgment debtor? Why?
I will contest the same. I will contest. I will file affidavit because I am in possession.
Sir, unfortunately, you have been your advice on this is unacceptable. Secondly, why did you file the appeal from this order? The court was proceeding for cross-examination to determine your right in terms of order 97, order 21, rule 97. There is nothing wrong.
Yes. My lord,
you say that you have an independent right?
Yes, I have an
Yes, the court will
independent
examine
right.
it.
One thing, my lord.
Court will examine the same.
Yes, court will examine the same. But one thing, my lord, I may be permitted to add in
No,
the
not
execution case.
necessary. Not necessary. Independently, you are permitted to challenge it under order 21, rule 97 to 99.
Yes, yes, I know, my lord.
No, what do you know, sir?
My lord,
You have challenged filing an appeal. You are only interested to delay the proceedings.
No, your lordship kindly fix the matter.
I'm
Within
fixing
the
it here. Now, today I'm fixing it.
No. I am praying before your lordship. Kindly see the judgment. The judgment coordinate bench passed an order.
Yes,
Your lordship kindly see. I may be permitted to serve the copy. Then your lordship pass.
I will not direct you to serve any copy here, sir.
Yes,
I will
my lord.
decide it. No service.
No. Service not করে হবে না.
No service, sir.
Yes, my lord. Kindly see. My lord, kindly see. I haven't, my lord. The order passed.
A different issue altogether.
Yes, but the principle is that. The principle is that. I may be permitted to.
Where is your application order 21 rule 97? Where is your application order 21 rule 97?
Yes, my lord, I've given. Well, kindly see page 12.
Page
14. Page 14.
This is order 21 rule 97.
No,
Are you sure?
no. No. My application is, I'll see page 16. 16.
Order 1 rule 10.2.
Yes.
Sir, execution proceedings is going on.
Yes.
There is no order 1 10.2 there.
But
I please understand, hear me. Execution proceedings is going on.
yes.
You are entitled to defend yourself, saying I have an independent right under order 21 rule 97, which the court has rightly treated your application to be a one under order 21 rule 97, and fix the matter for cross-examination. A decree will be passed, deemed decree will be passed therein.
Yes.
Yes, again you are saying yes and again you are challenging.
One thing I am praying before your lordship, give me chance to serve copy.
Why will I direct you to serve
No,
copy?
one thing, for the ends of justice, your lordship. Otherwise, I am an old woman. My lord, I will be deprived.
By the time service will come back, you will become more old.
Yes.
You will become older.
Maybe.
Yes.
Now I am older.
So it is better I dispose of your matter when you are still young.
No,
Yes,
your
sir.
lordship kindly fix the matter February.
No, sir.
Oh, no, yes, Lord, it is my request. It is my humble prayer before your lordship. Kindly fix the matter February. I will serve. Then in his presence, the matter will be disposed of.
No, sir.
Yes, my lord. You kindly consider it. Kindly consider today is the post Sankranti. Your lordship knows, my lord, the Punno day. Today, your lordship can.
Today is the day to do all this.
Yes, lordship.
Absolutely.
Yes.
To finish up the matter, sir.
No, man, kindly see. I am praying before your lordship. Kindly see page 13. My mother filed a suit. The defendant gave me crops. My above daughter did not take any crop as they married, living separately, and their father requested him to not to crops ill. I leave.
Sir, I'll grant you leave if necessary. You apply before the court by filing an application under order 21 rule 97.
Well, I am praying before your lordship very enough. Your lordship give me chance 1 month. They will come, then your lordship pass in their presence. It will better, my lord. I am paying. I am not wasting your time, my lord. It will take time 5 minutes.
Sir, I am here for this purpose, sir.
Yes, my lord.
I am not wasting time, judicial time, sir. I am here to decide.
I am requesting your lordship, kindly give me chance to serve the copy.
Any other request you have, I will accept your request. Any other order you seek, I will grant you.
Any order means serve the copy.
No, sir. Any other order.
As your lordship desire.
Anything else? Anything
Let
else?
my lord, your lordship give me chance to make an application before the court below.
Yes, you go.
Rule 100. Your lordship kindly indicate it. Then
Kindly come to page 53. 52.
50?
53.
Yes.
Second paragraph. Kindly place second paragraph. Read it.
Yes. On closure scrutiny. On closure scrutiny.
On close scrutiny.
In close scrutiny of the record, it come to my notice that the execution has been filed, degree passed in title. Judgment data preferred an appeal such and such. In judgment was passed, affirming judgment and degree such and such. Thereafter, degree holder initiated execution case, and after issuance of writ, bailiff of the court could not deliver the position in favor of the degree holder due to obstruction caused by the judgment data. Judgment data.
Please
I
read,
am the stranger. I am the stranger person. I am in
Please read, sir. Please read.
For the reason of which degree holder preferred another application. Order 21 rule 97 which registered in case number sir, which proceeding of the which case the instant petition was filed by two aforesaid persons for their implementation in the status of the judgment data. It is settled law that executing court cannot go behind the degree which has come before the court for execution. In the judgment degree passed in title suit number, the aforesaid person were not listed in the dependent category. They are nowhere related with the defendant. The judgment of the title suit was passed against the defendant who was judgment debtor of this case, and judgment and degree is binding upon the judgment debtor title suit number, which has been filed by the Sita Rani Mondal, which is mother of the petitioner. A different suit, and judgment is not binding upon the petitioner of the instant petition, since the petitioner were not party in the original suit, so they cannot included judgment debtor in the execution case. Very well, my lord. The finding is very good. But I am in now position of the property in question. You kindly see.
Kindly read the civil procedure code for that purpose. Instead of making arguments, kindly read civil procedure code. Once you become a judgment debtor, you will be bound by the decree and you will be thrown out of the property.
I am not in judgment debtor. I am the stranger.
Correct.
I can make an application.
Therefore, you have understood that you are not a judgment debtor now.
No.
So why are you making an application under Order 1, Rule 10?
My lord,
Which in any event is not
for the benefit, for the interest.
of the decree holder.
No, judgment debtor. Add me.
For the interest of the judgment debtor.
For the interest of the judgment debtor, I may be permitted.
For your own interest.
Our own interest.
Correct. So therefore,
I am
what will you do?
One thing.
Please stop. Kindly come to Order 21. Come to Order 21.
Civil procedure code. আছে বই বাবু, extra বই আছে।
So you are not ready with the papers also, unfortunate. Now the application under Order 21 has been filed. Rule 97 has been filed against you. Against you.
No. That was filed against the degree holder, again judgment debtor in the title suit number 81/2001. I am not the party in that suit. And you see, on close scrutiny of the record, it come to notice that the execution has been filed a degree pass in title suit number 81/2001.
You move under 99. You move under 99. You have an independent right.
Yes. 101 also. 101 also. I
101 will be decided. 100, 101, he will decide the issue.
But
and
one thing, my
under
lord,
103, it will be the
my independent right cannot be thrown out. My independent right cannot be thrown out. Under Order 21, Rule 101, my independent right cannot be thrown out because I was not a party in that.
Place page 16. Place page 16.
Page 16.
Yes.
Yes.
Yes, place it.
উপরুক্ত মোকদ্দমা নালিশি সম্পত্তির মূলধনী শান্তিরানী মণ্ডল অত মোকদ্দমার ডিগদারের পক্ষে মোকামে একখানি সত্য ঘোষণা পূর্বক চিরস্থায়ী নিষেধাজ্ঞা মোকদ্দমা যার নম্বর টাইটেল নাম্বার 24/2013 আনয়ন করিয়াছেন, যা বিচারাধীন অবস্থায় রইয়াছে। নালিশি সম্পত্তি নিম্নবর্তিত পক্ষগণের মাতা এবং
Where is your TS 24 of 13? Where is that?
Yes, kindly see. Page 12.
So you have filed a separate suit.
My mother. And my lord, kindly see the judgment, page 13, and degree also kindly see. Same property. Your lordship kindly see. I am not misguided, your lordship.
100%.
Well, kindly see page 48. This is the digital property.
Monday করে দাও তো। Monday. Not this week, not this week. এটাকে ডেকে দাও সঙ্গে আমি ওটা ডিসাইড করব।
Monday.
Yes. দেখো পয়েন্টটা দেখো।
Monday some difficulty, my lord.
Yes.
In my part, Monday, my lord, some difficulty. Next month.
Having heard the learned advocate for the petitioner, let this matter stand adjourned and appear under the same heading on Tuesday.
Tuesday. My lord, I will serve the copy. The whole purpose will be served.
Not necessary. Matter will be over before that. Matter will be over without serving, sir.
No, I'll get justice before your lordship.
Yes, call the next matter.
Yes, your lordship can.
Adjourn till Tuesday.
Item number 130 can adjourn for 1 week, matter.
Yes, Tuesday.
Tuesday, matter.
এই জাজমেন্টটা নিয়ে নেব জাজমেন্টটা
Matter will be fixed.
Wait, your matter is called on.
No, matter. Tuesday. 30. Item number 130. Adjourn for not this week. But I am busy. I will busy matter on Monday, my lord.
It's been already called on. Sorry, I can't.
113.
তাহলে আমারটা কবে
Already called on. Yes, call the list.
My matter is fixed on
Tuesday.
get
My matter will also fixed by Tuesday.
I passed an order in your matter already. Sorry. Yes, call the next matter. 120, 122. Who's appearing?
My lord,
120.
I'm for the petitioner, my lord.
Yes.
It's a matter relating to a direction for expeditious hearing on matrimonial shoot. My lord, I am the wife.
Who are you?
My lord, before the court of law.
Who are you?
My wife.
Wife.
Wife, my lord. And case was filed in the year 2021, my lord.
Yes.
13, my lord.
Who filed it?
My lord, wife filed, my lord.
What does the husband do?
My lord,
what do you do, sir?
housewife. Huh? I'm a
What do you
housewife, my
do?
lord. A housewife, my lord.
You are a housewife. You are praying for expeditious disposal. What is the hurry? Yes. Has
My
written
lord,
statement been
my
filed?
lord, last, my lord, about my lord, more than 3 years it is pending, my lord.
Has written statement been filed by the
My lord,
husband?
that has been filed, my lord.
Yes.
That has been.
What your junior is saying? Where is the copy? Where is the copy of the written statement?
Well, that has not been annexed.
You will not annex written statement. You will come for expeditious disposal. Where is that? You think the court will pass whatever orders you ask for? Where is that? At all, whether the written statement has been filed or not.
And my lord, order dated, my lord.
Where is the order sheet?
My lord, I have, that is annexed.
Where is the order sheet?
Well, that is annexed, my lord.
Annexed?
Yes, my lord. Order dated 5th August 2023. Respondent appeared by filing Bokalatam and praised for filing WS had considered and time is allowed.
Sir, what have you annexed? Page number 10 is different. The present application has been filed. Interior praying for expeditious disposal. The present retributional application has been filed. Interior praying for
Lordship, I am the plaintiff petitioner here in Lordship. This is a suit for injunction under Section 44 of the Transfer of Property Act, Lordship. Actually, the plaintiff
suit for
injunction under Section 44 of the Transfer of Property Act. The
44.
Lordship, what happened, Lordship? The plaintiff is plaintiff was a tenant in respect of the defendant number 2. Lordship, during the course of the tenancy, the defendant number 2 offered the plaintiff to buy out the property, and for which the plaintiff agreed. And on periodically, he paid more than rupees 3 lakh as a consideration amount. but the defendant number 2 refused to execute the sale deed in his favor. Subsequently, the plaintiff filed this suit under Section 44 of the Transfer of Property Act. Later on, Lordship, the plaintiff has filed an application for amendment under Order 6 Rule 17, incorporating certain clauses which have been rejected and challenging, which I have came before your Lordship. Lordship, by the amendment application, Lordship, if I place Lordship, page 37, Lordship.
It will change the nature and character of
But
the suit.
Lordship, the moot.
You want to specific performance. You want a Section 44 application to be converted to a specific.
But
performance.
Lordship, the moot issue, Lordship, the involved in the plain, Lordship, that absolutely indicates that the specific performance of the contract issue, Lordship.
Section 44 is different. Specific
Lordship,
performance.
stranger purchaser, Lordship. This is.
I will not allow this also.
Lordship, to avoid multiplicity of proceedings.
File a suit. Your point of limitation is involved. Please understand the date of your refusal is a very relevant and important. Article 58
Lordship,
of the Limitation Act will apply.
Lordship, the date of refusal is the cause of action arises since 2014, Lordship. And
matter ends.
But Lordship, on series of occasions, we have approached the defendant, Lordship. But
so what? You have not filed a suit, sir. But I cannot give you this benefit today.
But Lordship, this will only create multiplicity of proceeding, and Lordship, in Order 6 Rule 17.
A valuable right has already accrued in their favor.
But Lordship, in Order 6 Rule 17, Lordship has that.
No, certainly not. Not in this case. To treat it, this right that has accrued in the favor, allowing your application will tantamount to taking away your right. Yes. Bolo. At a Transfer Property Act, yes, sir. Anything else?
Lordship, this is my case.
Yes, Transfer Property Act,
Transfer Property Act.
You have a Transfer Property Act.
Lordship, right now.
Where is the plaint?
Plaint is, Lordship, page 17, Lordship. That is the plaint. Page 17 is my plaint page.
The plaintiff petitioner had filed a suit before the court of the challenge.
for expeditious disposal. The petitioner before your lordship is the plaintiff. The suit is of my lord 2023.
Suit for?
For injunction, my lord. Suit for declaration and injunction. The moot question is, my lord, regarding my lord dispute of setting up a my lord outlet of an air condition in the outer wall of my flat.
Yes.
The dispute with regard to setting up of a AC outlet by the defendant in this suit in the outer wall of my flat. The suit I have filed in the year in July 2023. My lord, I have annexed the orders, my lord.
Where is your flat?
Pardon, my lord.
Where is your flat?
Plan.
Flat. Who is preventing you?
Not preventing me. The defendant has installed his AC outlet on my outer wall.
On your outer wall?
Yes.
On your outer wall?
On my flat's outer wall.
Which floor do you reside?
On the ground floor.
And he has installed it near your
Yes, my lord. First
near
floor, my
the
lord, I pardon.
above the lid.
beg
The
pardon,
where has
first-
the AC been installed?
Pardon, my lord.
Where has the outer unit of the AC been installed?
My lord, it is installed just outside of my lord flat. On my outer wall. On the outer wall of my flat.
Sir, you are residing in a flat, sir.
Pardon.
Please
Yes.
appreciate, sir. The person who is residing, he is residing on the top floor or below you? Do you know where is he residing?
Lord, that is not stated in the plaint, my lord.
Sir, do you reside in a flat?
No.
No, you do not reside in a flat. Ordinarily, sir, if you reside in a flat, you would know that there is very lack of space. So the outer wall of the neighbor's flat is utilized for at times installing an air conditioner,
My lord,
which is
so-
very
so
close.
from the cross
for the
title of
purpose
the
of
plaint, I find,
convenience.
my lord, I reside in first floor and the defendant
Outer wall
reside-
is not your property. Outer wall is not your property.
But my lord, for that reason, my lord, your lordship, if your lordship kindly take
File
the
a suit
plaint-
for that purpose.
Yes, my lord. That is why I have, my lord, at the very first, my lord, I have submitted this to your lordship. Otherwise,
Did you seek an injunction?
no, my lord, I have not. I have sought for a mandatory injunction, but not interim injunction.
Fancy litigation to go on.
Pardon, my lord.
This is a fancy litigation, sir. Where is your plan? Where is the sketch plan?
The sketch plan is not.
Where is it? A photograph.
My lord, it was annexed with the plaint, but I
Where
have
is the
opted-
plaint?
I have the, my lord, kindly take, my lord, last 3 pages.
Where
of
is the
certified
plaint?
copy. Last 3 pages of the certified copy.
Yes, I'm on that. Where is the photograph?
Lord, that has not been supplied. I have annexed the entire certified copy. The annexure.
You
with
bring
the
it,
plaint
sir.
has not-
Unless I see it, I'm not happy.
But
Unless on
only
this,
I am beseeching your lordship
I have
is
to,
for-
I have to. You see, my conscience has to be clear that this order can be passed in this matter.
Only I am beseeching your lordship for expeditious disposal. The learned trial court is fixing, my lord, only 2 dates. And my lord, in a year, my lord, the learned trial court is granting, my lord, several opportunities to the defendant.
Let a copy
while
of the revisional
filing-
application be served on the opposite party. This having heard the learned advocate for the petitioner, let a copy of the revisional application be served on the opposite party. List this matter in the monthly list of March 2025 under the heading New Motion 1. Small issue, sir.
Yes, my lord, that is
Sir,
why-
resolve it. Section 89, I'll send for mediation. It is better. What will you do with this, sir?
Lord, I am led by my senior minister. May I incorporate?
No,
his name?
no, no.
He is on his legs before another court, my lord.
He is there. He's not. His name will not be incorporated. Dido. What fancy? What is this going on? Outer wall of your, you understand. In a flat as it is, there is lot of space crunch. So I wanted to know where he resides. He said on the first floor. Now naturally, this gentleman is on the second floor, perhaps, or the ground floor. So where will he put the AC? The outer machine, now the split machine. Maybe he has put it on near the lintel or above the lintel. So which interferes with your, does not interfere with your flow of right and air, but on the outer wall. Why is so agreed by this? After all, you reside in a flat. I'll send it for mediation.
Lordship sends it for
Yeah, I will. Let's call. That's why I've served direct service.
Lordship.
Unnecessarily, what will you do with the suit? Mediate and finish it off. If it is to be, according to you, if the position is required to be changed, if it can be mediated. Now the expenses has to be borne, and generally it will be around 5 to 7,000 rupees, because the AC gas is there. How many years it is already installed?
But it's installed, my lord, in 19th April 23.
23. So
Almost 2 years.
almost 2 years. So this everything will leak once you try to reinstall it. So you understand. So it can be resolved. If this can be shifted, it is better. You sit down and talk. I think these matters should be, for a suit of this nature, unless you are a veteran litigant, you want to fight out litigation. Yes, call the next matter.
My lord, may I only say one thing? I shall.
No, place the new motion 1, it will come up.
New motion 1, or in the meantime, I'll serve copy.
Yes. Affidavit of service. Full of you.
Great.
125.
New motion 1 means within few matters, because I'll send it to mediation. I'll not pass. Unless you can agree, sit down with the gentleman. Maybe your friend will be there. Whosoever appears, you can talk to him.
I shall.
Yes, call the list. 125, who's appearing? None appears, dismissed.
Item number 126.
Lordship, it's my application, Lordship. I am for the petitioner defendant, Lordship. Suit for recovery of khas possession. Lordship, summons served on Lordship 4th August 2023. I received summons. After that, Lordship, first appearance, Lordship, 17th October 2023. But without time, Lordship, 8th January 2024, I filed 71 and 72 application, Lordship. That application rejected on 8th, same date, 8th January 2020.
When did you appear?
Lordship, I first appearance, Lordship, 17th October 2023, Lordship. And that day I filed time petition.
And when summons was served, when?
Summons served, Lordship, 4th August 2023. Lordship, without time, Lordship. 71 and 72, Lordships, 8th January 2024, Lordship.
Where is the summon?
Lordship.
Where is the summon?
Lordship, page 10, Lordship.
Summon did not indicate the date and time.
No, Lordship.
Page?
Page 10, Lordship. I annex the plaintiff, Lordship.
Summon.
Lordship,
Where is the summon? Your contention cannot be accepted. Since you have received the summons on 4th August, it is time barred, madam. Matter will come to an end unless you can demonstrate that the summons did not show the time. Come Monday, bring the summons. Monday. No. Not this week. Or not this week and not next week. It will not be on because it will require some more time to find out the summons. Or not this month you want? What do you want?
not this one, Lordship.
Not this month. Next month list group 1 দিয়ে দেবে না কোনো অর্ডার হবে না গ্রুপ 1 দিয়ে দেবে এটা কি শুরু হবে
Monthly is February, Lordship.
You want in group 1? I place it below. Place it below.
No, Lordship. Here, Lordship.
Make up your mind, madam. What do you want? ঠিক আছে group 1 রাখো. But group 1, madam, it will be called on. And if you are unable to demonstrate, you are out of time, madam. Yes, call the next matter.
Item number 127.
Dismiss. None appears, no accommodation has been sought for dismissal.
Item number 128.
128, Mr. Shogun Majumdar appearing for the petitioner. His mother is ill. Today
Since
he
an
left the
accommodation
court.
has been sought
No,
for
not-
on behalf of the petitioner, let this matter go out of the list. Mention
Not today, Lordship.
Mention later.
129.
Similar.
Criminal 130.
The defendant is the petitioner before my lord suit for declaration and recovery of possession. My lord, by the impugned order, my lord, the amendment of written statement has been rejected by the learned court. My lord, kindly see, my lord,
What are you seeking to amend?
my lord, I want to incorporate, my lord, the some facts, my lord. Initially, my brother was, my lord, running the sweet shop. Now, my lord, he got the job, and my lord, that was, my lord, the stated in the original written statement. By virtue of this, my lord, kindly comes to page 7.
Suit for?
Suit for, my lord, the declaration and recovery of possession. Now, my lord, kindly comes to, my lord, the written statement, paragraph 7, my lord, page 17. Page 17, my lord, the paragraph 7, I want to, my lord, the add some facts, my lord, after this paragraph 7. In the paragraph 7, my lord, I have stated that the suit, that the sweet shop, my lord, was run by my elder.
You want to incorporate the fact of adverse possession for the first time by way of amendment?
My lord,
Yes.
apart from that, my lord,
No, no,
apart
not
from-
apart. Do you want to do that?
Well-
Be very clear, sir. You, by way of amendment, you want to incorporate the fact, you incorporate a claim of adverse possession.
My lord, that fact is there, and another paragraph is also there. My lord, accepting that. My lord,
You want to give up that?
my lord, adverse person, my lord, another claim is required. My lord, by this way, my lord, that is.
So you want to give up that? Then I'll consider the rest. One by one. Make up your mind and come tell me. A liberal interpretation of amendment of the written statement, I understand order 8, rule 9. But adverse possession for the first time by way of amendment, never ending suit, sir. The suit will never come to an end.
My lord, that is also not inconsistent with one of the original written statement. My lord, the other facts, my lord.
Challenging the order dated. Anything else?
May I stop, my lord, and come? My lord, matter fixed with in the learned code below, my lord, on 25th March.
Where is your amendment?
My lord, amendment at page, my lord, 21. বিবাদী পক্ষ দেওয়ানি কার্যবিধি আইনের অর্ডার 6 রুল 17
প্রার্থনা, from that প্রার্থনা, প্রকাশ থাকে যে
the schedule of amendment as page 23. বর্ণনাপত্রে 7 দফা শেষে নিম্নলিখিত বক্তব্য ইনসার্টেড হইবে।
Yes.
মানে প্রকাশ থাকা আবশ্যক যে বিবাদী এবং তাহার জ্যেষ্ঠ ভ্রাতা মদন চন্দ্র দাস মহাশয় সোনামুখী পৌরসভার অন্তর্গত 2 নম্বর ওয়ার্ডের নালিশি প্রেমিসিতে মিষ্টান্ন দোকান চালায়া আসিতে থাকাকালে উক্ত প্রেমিসেসে এই বিবাদী জ্যেষ্ঠ ভ্রাতা মদন চন্দ্র দাসের নামে ইলেকট্রিক কানেকশন লওয়া হয়। উক্ত ইলেকট্রিক সার্ভিস কানেকশন নাম্বার সাচ অ্যান্ড সাচ, কনজিউমার আইডি সাচ অ্যান্ড সাচ। বর্তমানে মদন
চ্যালেঞ্জিং দি অর্ডার dated for
Item 131.
My lord, in 131 anti-petition, my application, judicial disposal, judgment suit number 75 of 2017. No interlocutory applications are pending.
When was the suit filed?
My lord, it was filed on 2017.
There is ejectment suit.
Ejectment suit. my lord.
No interrogatory applications pending. You are for the
My lord,
you are for the
for the petitioner, my lord.
plaintiff.
Oh, yes, my lord, plaintiff application.
The instance divisional application has been filed inter alia praying for a direction upon the learned civil judge, senior division, 5th Court, Alipur, district 24, Pargana South, to dispose of the suit, to dispose of the ejectment suit being number 75 of 2017 as expeditiously as possible. Now, as expeditiously, without granting any unnecessary adjournments to either of the parties. Having regard to the nature of relief sought for, the instant divisional application is taken up for consideration without service of copy, without prior service of notice on the opposite parties. Considering the fact that the pleadings in the pleadings complete, issues framed.
Yes, my 27 January is fixed for the framing of issues, my lord.
Considering the fact that the pleadings in this suit is already complete and as submitted by the petitioner, no interlocutory applications are pending. And from the order sheet, it would transpire that the learned court had proceeded to frame the issues in the suit. Yes, what has happened thereafter?
My lord, it's still pending, my lord. Issues are not.
Proceeded to frame issues in the suit. I am of the view that the learned trial court should take expeditious steps. I am of the view that considering the pendency of the aforesaid ejectment suit since the year 2017, the learned court should take expeditious steps to dispose of the same. Expeditious steps to dispose of the same. The house of observation, preferably within a period of 6 months, within a period of 6 months from the date of communication. No, kichu hoyni to 6 months now. Preferably within a period of 1 year from the date of communication. Disposed of. Without granting any unnecessary adjournment to either of the parties, provided no interlocutory application is pending. Yes, call the list.
132.
Dismissed. Yes, you are there.
Yeah, my lords, I am for respondent number 3, my lords. I am for the respondent.
Dismiss. None appeals for the petition.
Obliged, my lords. Obliged.
133.
My lord, I am being led by Mr.
Since an accommodation has been sought for on behalf of the petitioner, let this matter go out of the list.
Lordship, in this matter, Shivashi's Chatterjee is appeared, Lordship. He has fallen sick, Lordship.
Same order.
Application only today and tomorrow, Lordship.
Same order. Mention later. Yes, next.
195.
None appeals dismissed.
Item 136.
Tomorrow.
Item 137, I am for the petitioner, my lord, this instant revisional application is being praying for the setting aside the impugned order dated 10/4/2025 passed in money suit 15/18 of 2020. Kindly turn the page 55, my lord. 58, my lord, sorry. For application under order 6, rule 17, read under the section of 151 of CRPC. In page 59, my lord, the plaintiff came to learn that the date and the mode of payment as mentioned in the complaint is wrong. It is pertinent to mention herein that date and the payment mode mentioned in the demand notice and legal notice was wrong, which is totally unintentional from the part of the plaintiff. My lord, in page 60, the proposed amendment should be the plain paragraph number F in the third line from the top to delete the thereafter on 1st July 2016. This plaintiff has paid a total amount of 10 lakhs in favor of MSI Enterprise in 2 installments through RTGS, which is rupees 6,50,000 and 3,50,000 on 1st July 2016. And the defendant equivocally assured to this plaintiff that he would refund the money with a period of 12 months. And the sister of the plaintiff also paid a sum of rupees 10 lakhs in favor of MSI
In
Enterprise.
the notice, it was incorrectly recorded.
Yes, sir. Yes, my lord. That is why the proposed amendment is in schedule in page 16 is asking for that. And now, my lord, in the last paragraph, you have seen that the
Page.
in page 61, my lord. The defendant unequivocally assured this plaintiff that he would refund the money within a period of 12 months. And the sister of the plaintiff also paid a sum of rupees 10 lakhs in favor of MSI Enterprise by way of RTGS.
Order dated
Defendant in the
10th April 2024.
Applies. Just we stated the index. Now, well, the learned code below. Yes.
ডাকো দুটো ডাকো জানি 4টে অবধি করবো, আরেকটা দেখো আরেকটা দেখো, ডিসমিস করবো না, দেখো তো যদি কেউ থাকে। আচ্ছা দাঁড়িয়ে আছে। Yes, yes.
I'm appearing for the petitioner, my lord. My lord, this is my lord stay of execution. My lord, stay of execution, my lord, by the learned trial court. My lord,
Okay,
plaintiff.
come tomorrow because I'll be taking an original side matter. Thereafter, I have a chamber matter. Come tomorrow. Come tomorrow, sir. Okay, good.
My lord, copy was not served, my lord. Copy was not served, my lord.
First of all, succeed in your case thereafter service. Yes, it's called the original. Okay, I see.
This is my application under clause 13 of the. Huh?
Fixed pattern.
No, only one direction. No, no. I'll not even take 30 seconds. I want a direction.
No.
No, yesterday it was taken up, but your lordships had come to only direction to serve the on the respondent, nothing else. My learned senior is saying
Kindly don't entertain his matters. He today, through his solicitor, sent me off to Rajarhat Commercial Court because he could not go.
No.
Okay.
No. I was ready to go. There was
12:30 fixed matter. Solicitor called and said, you have to go right now. So I ran. Then when I said, where is Choyan? He said, he's not coming.
No. My learned senior said that he will not be able to go. He will not be able to go, so I'll go. But when he told that he will go, so I stayed back. Otherwise, I would have gone.
Not as innocent.
That mattered.
Chaudhary has eaten into my time, my lord.
Oh, this is very. Yes, when he has finished, I have to give reply.
But whenever I find him submitting, he only says this thing. It's finished. I know, my lord, from very younger days, he has been trying to control me. But now he's not even allowing me to speak. He's never allowing me to speak also, my lord.
On revenge, my lord, third day in court, court 14. Mr. Mitra was there, he was there. I was holding his brief. So he sent me inside before Justice DK said and said, go and start, I'm coming. Wonderful court. Then I see nobody. Very nervous, but I start arguing. And I look outside. We had that round glass through that I find it.
But what could have been better?
Nothing better.
That's the best way of
Nothing
starting
better.
off.
Wonderful court. And
I thought best place, and you always jump into the fire. That's the best we can start in this court. So I told him, okay, jump now. Now, my lord, I was placing certain judgments in connection with this matter, my lord, which is also referred to in my supplementary affidavit. My lord, I've already placed my supplementary affidavit. My lord, what I wanted to show was, my lord, that this company had come out of the BIFR. It was provided in this fashion, or rather opined by the Madras High Court by an order of 2007, my lord. Then, my lord, the same thing was found by the AIFR. My lord, the AIFR order, my lord, I could not place, but my lord will kindly take note of. My lord has supplementary. Just gives you. Madras AIFR. Page 7. But it kindly comes to page 7 of the supplementary affidavit. But this is the AIFR order. It's supplementary. But it kindly sees page 7 as a step towards rehabilitation of the appellant company. Efforts have been made by the BIFR for sale of surplus assets to finance rehabilitation scheme of the appellant company. BIFR had constituted an asset sale committee of 28 November 2001. Following persons were there. Now, page 8, the appointment of this ASC, has the Lordship got that? Though not expressly approved by this authority, however, by implications approved in this authority's order of 7th March 2002. So, there was a rehabilitation. There was a standing committee which was authorized to deal with because I had shown those orders, If your Lordship, once again, but I don't intend to, because your Lordship has seen them. So, there was a sale. Now, sale or an agreement for sale or whatever it is, there was a transfer, possession, and also, I have shown that agreement for sale before your Lordship. And, it was acted upon. Why I am saying it was acted upon? I don't know. Very curious question, Of 25 years of my practice, I've never understood this, No, why? Yes, I don't understand that, So, as I was submitting, Dunlop has shown in its balance sheet this amount. And, we are talking about a period where Dunlop was not in any kind of insolvency, neither winding up. Yes, that will be nice, yes. But today it's pretty warm, I'll say. Yes. So, Dunlop had acknowledged this in its annual returns as found in these judgments of Madras High Court AIFR, that this payment has also been shown and it has been made and acknowledged at a time when it has come out of VIFR and the winding up had not started. Now I want to say, in these kinds of applications, there are two types of applications which we generally get or which we used to get, because now, nothing of this sort mostly doesn't happen, So, one is a company had dealt with its assets prior to any kind of winding up petition. And then we come in for a disclaimer or for making that over to the company, or rather the transferee. Another is it happens within the scope, within the time period of the winding up petition, post winding up petition. So, I will refer to the judgments. The test which your Lordships have laid down is whether it is a bona fide transaction in its regular business. My Lords will first see that. Then your Lordships will see whether the quantum is not something which is unbelievable. It is not that your Lordships, even in auctions, your Lordships do not plausible. And if it is bona fide, then your Lordships proceed to deal with that in a manner in favor of the transfer. Or else what happens, your Lordships are here to see the balance, both with creditors and the debtor, as well as any further third-party transactions. Your Lordship will not do iniquity. Iniquity, Let us say I have a bona fide transaction. For the time being, your Lordship holds that it's a bona fide transaction. Your Lordship to do equity for other creditors will not turn back the clock then. Because then your Lordship is promoting a breach of an agreement. So that is the basic test which has been laid down. Now may I come back to the 2 points which I was trying to make. This transaction admittedly made before this winding up petition. No dispute about that. Cannot be. Transaction made at a value at a value of 8 crores. And the State Bank, as the monitoring agency, had valued it at 8 crore 15. Plausible? This 8 crore, my lord, has been shown in the books of Dunlop. There is no dispute about that also. I was in uninterrupted possession because my lord, I had shown documents. If your lordship remembers, my lord, just referring, cross-referring. I'm not showing the documents again. But the documents of Talbot, documents of Eyelet, my electricity bill. So these all show that I was in possession. No dispute about that. At least, my lord, for equitable purpose, I can say it was performed. The agreement was performed. My lord, my learned junior is talking about Salazar's admissions. Well, very strangely, Salazar says in its reply that though it has said that I am owner of the 50%, it does not mean that I am the owner of the 50%. So, my lord, that is something which they will explain. How, my lord, when you say 50% owner, I still am not the 50% owner? I don't know. But again, my lord, since it fell from your lordship, that they will say. Here, my lord, this is one point which I'm also trying to argue before your lordship as the locus of Salazar in this application, which is before your lordship. Your lordship will first thing which will go against me, my lord, is that I have made him the party. I have made him the party. But I have made him a party, definitely, because, my lord, the original order, which has been stayed by the division bench, asking that this application should be heard out, recalling, I had to make him a party. But now the question which your lordship is looking into is whether I have a right of owning this company vis-a-vis the asset of the company in liquidation. And it is the official liquidator who should be heard on this. Why do I say this, my lord? Kindly appreciates, my lord. Salazar admittedly is not the owner of this 50%. Admittedly. Now, my lord, Salazar has been piggy riding, if I may, but that's a colloquial term, piggy riding, my lord, the agreement of GKW, saying that between GKW and Dunlop, there was a preemption clause. Now, my lord, it is also admitted, rather they have not been able to show, that there was any agreement between Salazar and Dunlop with regard to preemption. Now, why do I say this? My lord, preemption rights are personal rights. These are not attached to a property. I'll be showing judgment for that, my lord. তোর বলা শেষ, time up তোর।
No registered document, no stamped document.
তোর বলা শেষ বলেছি। You can't say. So, as I say, my lord, so he's appearing for Salazar, I believe. So, as I was saying, he has come at the right time. So, as I was saying, my lord,
I'm also there.
Salazar says it has a preemption right.
I'm sorry, my lord, I'm not very well, that's why I've come away.
Oh, you're there. Mr. Banerjee is also there.
I'm not well, that's why I've come away from court.
So sorry. How are you?
Better. Yes, my lord.
And I've got double trouble from two sides.
Wasn't too well, that's okay. I'm waiting patiently for Mr. Rai to finish one of his matters. I'm waiting for Mr. Rai to finish one of his arguments.
I must say this, you won't be feeling too well either today.
Yes.
So, as I was saying, my lord,
Yes.
preemption rights are personal rights. These are not attached to the property. And your lordship will show the Salazar conveyance. That conveyance specifically provides that if any of the rights contained in the agreement between Dunlop and GKW has to meander down to Salazar, then Salazar will enter into a separate agreement with Dunlop, which includes the preemption rights. That was never there. So where does he come from? What preemption right is he talking about? If he today, for the time being, if he doesn't have a preemption right, I will try and establish that. Does he have a right in this proceeding? No, he doesn't. Because he only has a right to participate in the auction. It is not his case that he is the owner of this property. It is his case that I should have, or rather Dunlop should have gone to him, give him the option to purchase because of the preemption right. And therefore my right or whatever agreement is bad. Maximum, that's the maximum he can say. But if there is no preemption right, he has got no locus to make any submissions in this proceeding. Now Malad kindly takes his opposition. That's it. Malad kindly takes page 3 very quickly. Malad, I will not read it, but I'll just point out what are the points they have taken. He is saying that the claim of ownership is barred by limitation. I don't know who is he to say that. 3 of the opposition, Malad.
Yes.
I don't know who this person is. He's not a creditor of the company. So I do not understand from where he's saying all these things that it is barred by limitation. Then there is conspiracy and collusion, applicant and the promoters, whatever it is. And he says prejudicing the vested right of the respondent number 2 to acquire the said property in terms of its preemption rights. So that is his only case.
Yes.
Then my lord kindly comes to page 4, para 7. These are the documents which I have provided in my opposition, or rather in my application, showing that he has admitted that I am the 50th owner. Now sees how it has been dealt with. Document of 25th September being annexed D to the said affidavit document annexed G are documents that is to have been acknowledged by the respondent number 2 also do not in any manner confer ownership of the said property. But I'm not on the ownership. I'm saying that you have acknowledged me. Vis-a-vis that, this application, you will have no say. You don't have a locus.
Yes.
Then my lord kindly sees something which is contrary to the document. The applicant in the past has only interacted, paragraph 8, with the respondent number 2 as a management company engaged by the company in liquidation. Well, what kind of?
He's a director of Salah, sir. He was affirmed it.
Yes. And the letters all say otherwise. Management company was Talbot. Then my lord kindly sees no legal effect. That's a different thing. Again, I say he doesn't have a right of saying all these things. Now, my lord, paragraph 11. Since the said premises, page 5, my lord, is in dilapidated condition and the building requires urgent maintenance work, and since the respondent number 2 was willing to exercise its rights of preemption, the respondent number 2 had in its application inter alia prayed be pleased to pass appropriate orders directing the official to sell the said portion to respondent 2 at a fair market value. But this has not been allowed. He has been rather allowed to participate in a auction. If so, an auction is held. Now, my lord, the valuation rules are not going into that. My lord will now kindly see the agreement between. It comes back to a supplementary affidavit. Comes back to a supplementary affidavit, my lord. This is the agreement. GKW and my lord Salah, sir, I believe. My lord, subject to what my learned friends will show, my lord, there is no transfer of any preemption right in this agreement.
Yes.
Paragraph 3, my lord, at page 13, talks about the agreement between Dunlop and GKW. And then your lordship will kindly come to the habendum clause. One will kindly come to page 23 onwards. So it is the property which is being transferred, half of the portion. And my lord, here your lordship will nowhere see any rights of transfer of preemption. Now kindly takes page 24, clause D. That the purchaser shall enter into an agreement with Dunlop, the co-owner of the vendor is of the said premises as to the compliance of such terms and conditions said agreement dated 18 July 1953, as are on their respective part to be complied with. And if everything was being transferred, then this clause wouldn't have been there. This is not a customary preemption like in inheritance. It was a preemption between two owners of a property. So if you have to transfer that right, you have to give that right. As I said, I will rely on judgments. It's a personal right, not attached to any property. And that is why this clause provides for that. That if you have to, then you will enter into an agreement with Dunlop. It is not there. So today, my lord, on the basis of this agreement, they are coming up before your lordship opposing my application. They don't have a better title than me, do they? I'm sorry, my lord, I shouldn't be. I'm asking myself, my lord. They don't have a better title. They could have done something else also, my lord, against me. Proceeded in other form. They have not done all those things. They have come up before this court saying that I have a preemption right, but that has not been allowed. Show that judgment.
Remind my learned friend, Justice Orijit Banerjee.
I will show the judgment. I know.
Allowing.
No. Yes.
Appeal.
After that, the division.
Mr. Chaudhary, let him conclude.
Yes, my lord. I think like he is showing, he is saying that I do not know my brief. I'm sure he also doesn't know his brief. Not a problem.
I never said you don't know your.
No, that's what he said. Where is saying this from, my lord? That's why he said so, my lord. And if you had a preemption right, then there wouldn't have been any auction. Very interesting. If there's a preemption right, why will you have an auction?
The auction only shows the preemption right, Mr. Lee. I'm so sorry.
Sorry, Mr. Banerjee, I couldn't hear you.
Auction right only records my preemption right. When the auction is directed, it records my preemption right.
I will show that.
That's why I'm to match, my lord, whatever offer comes.
But I had on the first day when you,
No.
I said 1 hour, 15 minutes.
Half an hour is over.
So give me 45 minutes, my lord.
Yes.
My lord, I am opening up. I am unfolding. Seize, my lord. I am unfolding the flower, so they are having problems. Even if I am opening my eyes with my eyelids, then also they have problems.
Mr. Chaudhary, let Mr. Ray
You have
finish.
an eye for an eye.
কবে চেম্বার আছে আজকে তো আছে আর কবে চেম্বার আছে
No, but Justice Sen used the best expression. If the eyelid is open.
ওটা এগিয়ে নেবো কালকে করবো আর সামনের সপ্তাহে আছে কিছু Tuesday.
You will find nothing but an eye.
Mr. Right, Tuesday?
Tuesday.
Yes, sir. Yes.
Tuesday? 3:30?
3:30.
Yes, sir. Yes, sir. Great.
Sorry, Mr.
Yes,
Banerjee.
yes, sir. Yes, yes. Yes, sir.
I'm sorry, my lord.
He said already, he has acknowledged it. Mr. Rai, learned advocate representing the
Grateful, my lord. I'll come back. I've only got এই তো judgment. 19টা judgment আছে দেখাবো। না আমার।
এই লিখে দাও।
যে কে দিয়েছে
19 plus 2 21
তোমাকে যারা দেয় ওয়ার্কস অফ আর্ট
দাদা মামলায় কিছু না থাকলে ভয় দেখাতে হয় Grateful, my lord, very grateful.
He's got at least 19 judgments.
The spiral,
Sure. What can I do?
spiral winding,
Sorry, my lord.
the spiral winding and hand it over.
But I may not be.
There he is.
Let me see, my lord.
Yeah, if you want
Grateful.
19 judgments, make a spiral winding and hand over.
Obviously, my lord, may not be, my lord.
আলাদা, এটা ওকে দাও। ওকে দাও।
My lord, I'm learning this branch today, so slowly and steadily I'm trying to get through. Mr. Chaudhary, my lord, has been for the workers for such a long time.
You're all learning, Mr. Ray.
Now he has suddenly become unworkable with Salah, sir.
Yes.